We're just waiting for the chairman to start.
I'll start it off here.
Okay.
Can everybody hear me all right, whether you're on or off? Okay.
We can.
We're going to call the State of Nevada Department of Indigent Defense Services, the board to order. It is just, well, Marcy says it's 1 o'clock. I say it's 1:03, but we're ready to go. All right. Can we get a roll call, Cindy?
Sure. Good afternoon, everybody. Mayor Bob Crowell.
Here.
Chris, excuse me?
Nope.
Chris, okay. Chris June Kiliani. Professor Ann Traum.
Here.
Laura Fitzsimmons.
She said here.
Rob Tellis.
Here.
Julie Kavanaugh Bill.
Here.
Joni Easley.
Yep.
Lorinda Witchman.
Whitman, I'm here.
Dave Mendiola.
Present.
Jeff Wells.
Here.
Drew Christensen.
Here.
Kate Thomas.
Here.
And Justice William Maupin. I believe we have a quorum.
Item number 3 on the, let's take up public comment so we know where we are. We just did roll call. I don't, up here in the north, I haven't heard of anybody, nor has Marcy heard of anybody who wants to speak on public comment at this time. We've got other people who, you know, I know they're here. Franny is one. If I don't know if John Lambrose is gonna get on or not, but if anybody shows up, they're welcome to speak. We'll take care of it. Anybody know anybody down there that's on public comment? Okay, the record will reflect that there's no public comment. Let's move to item number 3, approval of the minutes. February 28th, 2020. Everybody had a chance to look at those?
I thought they looked good. This is Joni Eastley. I'll make a motion to approve.
Motion's in order. Thanks, Joni. How are you doing?
I'm doing terrific. Hope you are as well.
Yep.
Second.
We're all doing all right. There's a motion and a second on the motion. Discussion. Hearing none, all in favor signify by saying aye.
Aye.
Aye. Can you clarify who seconded it for the record?
Who?
Can we clarify who seconded the motion?
Joni, who seconded that?
Lorinda Whitman.
Lorinda did. The Nye County folks, they're right on top of it. Good. Okay, let's take up item number 4. This is a fun time and it's a good time. Let's, Ann, Professor, you want to take over on the presentations for student volunteers? You want to do that?
Yeah, so did you want to recognize first and then have them present second?
I do. Can we do
Okay.
that?
Yeah, that'd be perfect. So, so I think that we're joined by 6 students today. So I think maybe just one is missing. So We're joined on the phone by Aiden Kidbede. She's a 3L who's graduating. I'm not sure if Christy DuPont joined, but she was going to join.
I'm here.
Okay.
Hi, Professor Trom. Hi.
Hi. So Christy DuPont is also on the line. She's also graduating. Grace, are you out there? Not okay,
Yes.
Grace. Oh, great. Perfect. So Grace Warburton is a 2L. She's been working this semester, so she's not graduating. She'll probably continue doing this work next year. Misha Ray is I think is on the line. I saw her. She is a part-time evening student who'll be graduating next year, not this year, and she will be presenting. Amanda Stafford is here. She's a graduating 3L. She'll also be presenting. And Zach Meyer is here. He's a graduating 3L, and he'll be presenting. So I just wanted to say a little bit about all of the students first. So as you know, in the bill, AB 81, there was a requirement that UNLV partner with the board and look into ways in which the law school can encourage indigent defense students and professionals to take interest in indigent defense, particularly in the rurals. So at the beginning of the year, I put a call out to the students, just the entire student body, to see, who would be interested in doing this on a volunteer basis. And I got an overwhelming response. I can't remember what the number was, but it was probably in the neighborhood of 25 or 30 people responded to that call. So because I had so many people, I just decided to stick to 3Ls. And I convened a little group, and we met sort of regularly in the fall to really come up with some ideas. And so what you'll see in the presentation is a snapshot of those ideas that Amanda and Zach and Misha will present on. And then in the spring, they did less of that work, but Amanda and Zach and Grace all stepped up to actually help the department on some research issues. And Amanda was decided to do sort of a 1-credit research assistance on that. And so she really took the helm, but Zach and Amanda and Grace together just did amazing work helping the department. So really, this is just a testament to our students being amazing. To step up and do stuff on a volunteer basis is phenomenal, and to really just see the sort of greater value of their work and thoughtfulness being applied at a statewide level is really exciting. So I hope that this is step 1 of what will continue to be a multi-year process. What the students are going to present on today is really just baby steps, and I hope that in the future I'll have more students, including Misha and Grace, who will carry that on. And I also know these students in terms of what else they do around the law school, which is phenomenal. So we're just really lucky to work with them in so many different ways inside the classroom and outside the classroom. So one other thing is I've been meaning to introduce Misha, who's from Winnemucca, so she's an actual rural person, and to I'm just like.
Hear that?
Huh?
Just say it again. We're on mute.
An actual rural person.
An actual rural person, yes. And
about
I'm
that,
just
Julie?
looking. Yeah. So I've been meaning to make it. Sorry, I'm just like a little looking for my. So I'll just do that when she talks. I'll just say a little bit more about that. So now we're gonna hear from. I think our order was Misha first, and then Amanda and Zach. So Misha, are you ready to start?
Yes, thank you.
Great.
I'm in my car, so I may turn off the video. It might be a little distracting, so I will turn off the video, but I wanted you all to see me before I did that. So hello and thank you. Now I'll turn that off. Wonderful. Thank you, Professor Trom. Like Professor Trom said, my name is Misha Ray. I grew up in rural Nevada. I lived there for 18 years until I went to college. I went to college in Reno, came down to Las Vegas, and now I'm in law school. As mentioned, I'm a part-time 3L. I'll graduate next year. My family still lives in Humboldt County, and I make that drive from Las Vegas as often as is feasible. It's a little bit of a long drive, so we only get to do it a few times a year, but I love going through Austin. That's my preferred way to get home. It's just such a lovely drive. So when this project became available, when Professor Traum put out that call for students to be involved in this, I have always looked for any project that has a rural connection because it holds such a special and familiar place in my heart. So I knew that I wanted to be a part of it, and I am very proud to have played some small efforts for the last several months with other students who have either a passion for indigent defense, for rural Nevada, or for both. And I count myself in that category. So I had the honor of participating, and one of the ideas we came up with, and I'll present just briefly on two of those ideas. One of them was an externship program, and this is close to my heart because I just love the idea, and I think however we went about it, it could be extremely successful. So implementing an externship program throughout the state with a few options that we can analyze and look at based on their practicality over the next several months. But one of them would be a traditional standalone summer externship with individual counties based on their needs. Or we could do an alternative spring break option, which could be really fun and have that be about a week-long program that either students spend a day in a few counties. By that I mean you spend one day in one county, travel the night, wake up in the next county, and so on and so forth, or spend the whole week in one county. Could be a really fun option if there's a time commitment issue. Or we could go into the existing externships within Washoe and Clark County and have those externships possibly implement some kind of rural rotation. So if a student is going to spend the summer in Washoe or Clark County doing an externship, perhaps they could do a 1-week rotation in Fernley, or they could go to Elko, or they could go to Humboldt, or they could, spend some time in Tonopah and do some work in those counties. Or, of course, doing an externship within the Department of Indigent Defense, also a very solid option. So whether or not all 4 of those opportunities become realistic, or maybe only just one of them based on practicality, those are a few ideas that we came up with. And then the second idea was for the school, or rather the students, to create a student group that's focused on the whole state. It's not yet named. Professor Traum, we've been calling it the Greater Nevada Student Organization, but we want to come up with a different name, something a little bit more catchy. But that's what we're tentatively calling it. And because there are so many student groups that exist for a variety of topics, there's public defense student groups, there's public interest student groups, there's criminal defense student groups, but a lot of students don't understand the needs of the rest of the state. They're mostly familiar with Washoe or Clark County. And of course, the opportunities available in the rural counties are different, but they're certainly no less critical. So by introducing the rural counties through a student organization that perhaps hosts regular events, has speakers, prevents information sessions, and so on and so forth, a student organization like that could really go to opening up the minds of the students who have likely come to Boyd, because Boyd is such a diverse law school. Students come from all over the country to attend Boyd, but there is a small population of us like me who comes from rural Nevada, and having that connection and having other students' minds and experiences open to what the rural counties offer could also be a really, really great opportunity. So that was those brief points on those 2 ideas. I'll turn the video back on real briefly, but thank you very much for your time. And Amanda and Zach also have some great ideas that we came up with.
So I'm just going to take it back before handing it back to Amanda. So thank you, Misha. Misha is partly in her car because she's on her lunch break from work, just like, which I love the way that things happen in the Zoom world. And then the introduction I meant to make was that Julie Kavanaugh-Bill might be one of the first people that we sort of would love to invite to the law school for just that difference of perspective. And I've been meaning to connect you with Misha. So now you have this connection, but we can follow up with the person-to-person connection.
Sounds good.
Trump,
Thank you.
Chair Crowell. This is Dave Mendiola, Humboldt County. It's appropriate you let off with Misha. We're very proud of the young lady, and you're welcome back to Humboldt County anytime.
Oh my gosh. Hello, thank you.
I missed who was saying that. Can you say that?
Dave Mendiola.
Oh, okay.
I tell you what,
Great.
Dave, you've got one of the most beautiful cities in Nevada right up there that you live in. So, you know what? Have fun and know that you're highly respected, and we all wish we could move up there. Well, most of us wish. Anyway, good job.
Well, thank you very much, Chair. And same for all of you. We love Nevada. Everywhere we go in Nevada, and all of our friends, especially now during this difficult time. You've all been great. So, especially, you know, a couple of the rural counties that we work closely with, and specifically, I want to just really quickly call out Clark and Washoe County. You guys have really stepped up to help us. You're working with us right now to do some community testing stuff, which we're in great need for. So I thank you, all of you.
Good, very good.
That's great.
All right.
So,
Anybody else want to weigh in? Ann, go ahead, go.
okay.
You got it.
Yeah, Amanda, you're next, right? Okay, great. So welcome, Amanda. Thank you.
Hi, Amanda.
Hello.
Tell us
Hello.
tell us about yourself.
Okay. Look over. My name's Amanda. I am graduating next Friday, electronically for now. I grew up in Las Vegas for about 10 years, and then I moved around a bit and came back to Las Vegas for law school. And I've really enjoyed this experience, and I think that it's something that would be very valuable to more students throughout the years, and hopefully incorporating students into more rural areas and making those connections. So I was going to talk a little bit about the idea of having an Indigent Defense Conference held at Boyd. This is something we'd like to eventually see done annually. But so California has what they call a traveling training, where they have specialists and experts go out to the communities in Sacramento, Fresno, and San Diego, and they invite all the adjacent rural areas to come in to see these experts and to kind of have these CLE/training session type situations to be more available to the rural communities. And so this is something that we would like to see in Nevada, and we think that Boyd would be a great home base for this kind of a conference. We kind of saw 3 main connection points that could be made through this conference. One, a connection to the wider community, to have the indigent defense professionals know, you know, who are the experts in this area? How do we contact them? Who's everyone kind of using? What do they like? What's a good lab to use? Those kind of things, to have all those resources known and available. The second would be, and in no particular order, a connection to the university and to the students. I know myself and the students that I've worked with on these projects have really enjoyed it, and would love the opportunity to help create a pipeline of students directly who meet people in the rural community that they then want to go work in, but also to have options for things like pro bono partnerships. So if there's an attorney out in a rural community who needs help with research, then they've met these students through this conference, and they can have those connections and say, oh, we're going to kind of outsource this research assignment to these students at Boyd, and things of that nature. And additionally, to have those connections to just the other attorneys doing the same things in similar communities, so that every problem doesn't have to be faced on its own, but with having the support of other people who have been in that situation or have that knowledge. So mainly just seeing this conference as a way to give out those resources of people that we have and all of the knowledge that exists within the community. As Misha said, we talked about having a student organization. The student organizations at the law school love to put on events. They love to put on CLEs. They're required to put on a certain number of events. So this is something that we really see a lot of organizations being involved in. Again, like Misha said, having that broader Nevada connection group come in, but the indigent defense clubs, the criminal defense clubs, all those kind of student organizations working together on the ground at Boyd to put in motion, to have speakers come out, to have faculty talk, and really just a way for everyone to connect, at least on an annual basis.
there's nothing wrong with getting a virtual certificate either, Amanda. Don't worry about it.
Well, thank you.
When I was getting ready to get my graduation certificate, I'd already been drafted. And by the time I was supposed to go to law school, I was overseas. But you know what? Hastings kept a place for me for 3 years, and they lived up to that promise. So, you know, you deal with these things as they come down life. And boy, I'll tell you, you speak well. You really speak well. That's good.
Thank you.
All right. Ann.
All right, so thank you, Amanda. Amanda has just been a heavy lifter on this project, so I'm just grateful because she's not only speaks well, she's like great at herding and organizing and researching and writing, and so it's just really lovely as Marcy and Jared know, to be able to hand off a project entirely and say, can you just run with this and then get back to me when you get back to me? And yeah, it just all works beautifully. So we're just really lucky. All right, so last but not least is Zach. Zach is graduating 3L, as I mentioned. I've worked with him in so many different capacities. He was in two of my regular lecture courses. He worked on this project all year long. I've supervised his paper. I just had him in misdemeanor clinic for a full semester, so I'm going to miss Zach a lot. But Zach, why don't you just go ahead and let us hear what you've been thinking about.
Okay, thank you so much, Professor Trum. My portion of the project was, or is, pipelines and financial incentives, and the two have a lot of overlap. So basically, it's about what schools have done to entice graduates or lawyers to practice in rural communities. But in our particular situation, it's, you know, what have they done to entice people to indigent criminal defense in rural communities and, you know, to defend competently. But for the sake of sort of organizing my research, I like to think of it, you know, as like the pipeline and as a metaphor. You know, if you want the pipeline to work to transport whatever you're transporting from point A to point B, you need like propulsion or some sort of pressure, right? Or it's not going to work. And then you need to make sure it has like an unobstructed path. And so that's sort of the two categories my research falls into. The first being propulsion, like what can we do to compel people to go to the rural communities? But then, and of equal importance is that there's an unobstructed path, because even if we get you there, right, like what's keeping you there? What's going to be the reason you get involved in these contracts that we're so concerned about, or what makes you competitive compared to the problematic practices? So beginning with propulsion, basically Boyd can compel students to go to rural communities by just making it more visible that these do exist. They can integrate them into curriculum. They can, or we can, I should say, you know, open a clinic or just get more involved in rural practice, so it's not this like mythical other thing. I read, or I think it's the Arkansas Access to Justice Commission actually did a survey back in 2015. They attempted to gauge in their state what it would take to get students out to rural areas. And they face similar problems to us, but obviously we differ in very important regards. But they had a similar goal. They wanted to get people out to rural communities. And I should preface this with saying that while our goal is very specific as it pertains to indigent criminal defense, the larger issue of getting attorneys to rural communities is there's a wealth of literature on it, you know, when you do the research. And it's because some places just don't have any attorneys in the rural communities, let alone ones who are interested in criminal defense. So when I talk about states like Arkansas, Wyoming, South Dakota, and Nebraska, their goal is a little bit different than ours, but at least on the front of propulsion, they faced similar difficulties. So with regard to the survey, they asked the students what they considered the most encouraging or compelling aspects of rural practice. They ranked first the ability to have one's own practice and be their own boss. Second, the ability to develop and maintain localized clientele. And third, the perception of greater job stability.
They're very important, Chuck.
Oh, sorry, go ahead. Okay. Feel free to interrupt. I'm happy to answer any questions.
Anything free.
Please place yourself on mute until public comment.
It's all fine. I thought I had a question. But another aspect of the survey was, you know, what would be your bottom dollar in terms of an annual tuition reimbursement program, like a loan repayment program? And the students, again, in Arkansas said that $5,000 to $10,000 a year was the minimum. They said they'd be interested in summer work, but only if it was paid. And then they asked them what were the most discouraging factors. And number one was the perception that they would earn a lower income. Number two was the perception that rural areas offer fewer career and economic activities. And three was the distance from the nearest city. And they also went on to survey rural practitioners, and they asked, what gauge your willingness. They wanted to gauge their willingness as far as taking on an apprentice or someone that they could mentor. And while 90% said that they were willing to mentor a young lawyer in their community, only 44% said that they were willing to hire at their practice an attorney full-time or someone who would work part-time and do work elsewhere. So these figures, right, although they don't reflect Nevada because we are unique, we have a different rural-urban dynamic as opposed to Arkansas and like Midwestern states, I think they point out some very important factors here, and that's, right, we have people who are in rural communities, even if it's just, not just criminal law, you have the people who are in civil practice who might be spread thin, taking someone on, the prospect of that person leaving, or, to go along with the pipeline metaphor, I'll talk about seepage a little bit later, but them not sticking around makes it very difficult for them to, consider things like paid externships and internships. And I think what's of particular importance to us, especially given so I read the Sixth Amendment report and the way the contract situation works out in a lot of the counties, is that it's almost like a bidding. The lowest bidder gets the contract, right? And so while there is a dynamic, or there's something to be said about the difference between those in civil law as opposed to criminal law, when some of these firms are civil firms that are getting these contracts, and the only reason they can bid them so low is because they already have an infrastructure in place to support their civil practice in addition to the contract that they take. I think it's really important that we, appeal to the civil aspect of it as well, or at least equip students to, I don't want to say infiltrate, but, be a very good hiring option for these people as opposed to a burden. But unsurprisingly, money was the biggest factor. It seems that students are actually enticed by solo practice, but they're a little worried about ultimately what are misconceptions about rural practice. In a law review article from 2014 from the South Dakota Law Review titled "Planting the Seeds and Getting into the Field: The Role of Law Schools in Ensuring Access to Justice in Rural Communities." Robin Runge basically talks about dispelling misconceptions about rural communities and rural practices in schools. It's like what I was talking about a little bit earlier, which is dispelling this idea that it's this mythical, place where there's no electricity or something like that, or there's absolutely, no infrastructure and life would be miserable. It's a lack of visibility that I think is problematic in that regard, and that's what Runge sort of corroborates in the article. But students worry that, they won't have the same lifestyle, sort of reiterating what was brought up in the Arkansas survey. But they Runge emphasizes that students might not want to stay, and, if they don't want to stay, then that's a lot of time invested in someone who ultimately doesn't, help you practice, someone who can't be competitive and help you get those contracts and that sort of thing. So her solution, which she actually conveniently titles "The Role of Law Schools," is to develop curriculum and just make it more visible at school in the first place. So it doesn't have to be this monumental, earth-shattering change. It's when you're in a class like business organizations, you include something in the curriculum about rural practice, right? So if you're in rural practice, you probably need to learn more about individuals, or you need to learn about things that are germane to rural areas as opposed to just pumping people out into urbanity. But other curriculum includes solo practice curriculum, LLMs, and that sort of thing to prepare people for rural life. And again, I think it's a very important aspect of this is making students competitive. And there's a couple of ways they can go and address these problems. It gets get the contracts if that's the model that's still in place. They either can be hired or try to team up with the people at the firms or the practitioners who are getting these contracts, or they could go on their own. And although the latter seems rather daunting, I don't think it's impossible if we do have a strong basis for solo practice at Boyd, or at least preparing them in that regard. And so, yeah, that would make them more appealing to rural firms. It's just about making it visible and having those opportunities that Amanda and Misha brought up, where they go out to the rural communities, they actually get involved in clerkships and those sorts of things. But the second point here is sort of my analysis and what I think would be a great solution to the dilemma that we're trying to solve. And so I titled this "Removing Obstructions," because even if we have the loan forgiveness program and the financial incentives that get people out to the rural communities, right, that doesn't necessarily mean that they're going to be accepted or that someone wants to hire them or that someone wants to take on that burden. So the first sort of sub-metaphor I have here is seepage, right? The students who go there, right, we entice them with this 2-year loan repayment program or this opportunity to do this or that, but that doesn't necessarily mean they're going to stay. And so some of the research I did, I looked into Nebraska's solution to the problem. And Nebraska actually has a program where after doing their own survey, they acknowledge that people in rural communities, like students in high school, are more likely to return if they go to college elsewhere than someone like myself who, grew up in Las Vegas or something like that. And so they targeted students in high school who had, stellar GPAs, and they gave them the opportunity to attend an undergraduate college or institution in some of the more rural parts of Nebraska, but then they had automatic admission to the University of Nebraska School of Law. So basically, this was the most direct pipeline you can get, right? We pick you out of high school, we try to get you into a situation where you more or less commit to rural practice, and then through that, you go through the University of Nebraska Law School, and they prepare you for it. Now, obviously, there's some contractual stuff here, and some students might go and decide they don't want to go back to rural practice, but if you're playing the odds, people who are members or, have roots in these communities are more likely to return. But one of the ways these students, or that Runge points out, can be very effective in terms of marketing them or getting them involved in rural communities is by basically shouldering some of the costs at the law school itself. Boyd currently, I believe, gives us our student subscription to Westlaw and LexisNexis goes, I think, 18 months or something like that after graduation. So it's not impossible for law schools to offer their resources to attorneys who are out in the communities or the rural communities and give them that much to back them up, right? The student's going to have at least this resource. And as Amanda talked about just a little bit, if we start getting a clinic or something of that nature going on at Boyd, that person might be able to delegate the responsibilities, right? Oh, I have a boilerplate motion, or I have to do this subpoena. Well, let's kick it to Boyd's rural clinic. They're over there and they can fill this out. And I remember through our conversations about, traveling times and how difficult it is to prepare for trial, why aren't we preparing demonstratives for attorneys in rural communities? Why can't we do that? Why can't we be involved on that front? There was another center, it was in Wyoming, it's called the Wyoming, I think it's Rural Law Center. It's sort of along the lines of what we're looking into, but they just more generally address rural issues. So it's not placement of attorneys in rural communities so much as it is what's going on in the rural communities and how can we help. But they do things like legislative drafting. They do things, the faculty gets involved and they'll send people out to the communities and see how they can help with infrastructure. Now this, again, isn't, it doesn't address indigent defense in particular, but what I think this does is it gives us a model for, how can we make it so that, not like a pipeline where you have point A and point B, once we get you to the rural community, it's by, the law school doesn't want to help you. Why can't this be organic? Instead of a pipeline, why don't we just have a continuous flow where we have someone who's always able to access the law school or delegate responsibilities and try to tap into their resources. And what I think is particularly promising about this is just the nature of our predicament as opposed to other ones. So I've been talking kind of like, just rural issues in general, but I'd also like to point out that our particular situation, we could benefit extensively from this because in contract situations where, someone's, the Sixth Amendment report, I don't remember any counties in particular, but where someone is just willing to go as far low as they can, the race to the bottom in terms of, well, we'll take the lowest contract and then we'll just, I don't know, not put as much time as we could into someone, or at least that incentive's there that we think is problematic. And again, money is obviously an issue, and we don't have a blank check, for everything we want to do, but the law school can sort of, assuage that difficulty by throwing their weight behind whoever gets the contract, right? So if you have someone who the school is willing to work with, or they, whoever the contractee is, agrees to allow externs to get X amount of assignments or agrees to work with the Boyd Rural Law Clinic, then that person is automatically going to have access to Westlaw, at least indirectly. They'll have access to us helping writing out with motions and that sort of thing. So we could conceivably intervene in the actual award of the contract and say, hey, this is a competent professional, and if you award the contract to him, he will have the Boyd Rural Law Clinic supporting him or her. And so That's something I think is beneficial. But going back to Wyoming's sort of perspective, is that they do it from the entirety of the rural community or the issues that are faced. And I think that it would be less adversarial, right, to say, we're trying to put someone in here who's going to do the job right because you're doing it wrong, as opposed to, look, like the Wyoming clinic, we have a legislative drafting component. So what do you need done in the Nevada legislature in upcoming years? And I know that just from what I've done in this, and it's in a very early stages as far as the school's involvement, but the contracts issues that I've gotten into and just learning about the Nevada Constitution, I've talked about that at length in interviews. But for someone to be able to say, I took part in, helping, get proper irrigation in a county. I remember sitting with Professor Lambros and I was sort of picking his brain about these concepts, and he goes, it's great what we're doing. We're trying to get representation out there, but some of these people don't even have doctors, right? Like there's a larger issue here. And if we approach it holistically, I think that could be very advantageous. I think it would be less adversarial, less like we're trying to police you, as opposed to, we're here to help in any way that we can. And we can sort of, throw our resources and weight behind the people who are bidding on the contracts in a way that's both beneficial to students, keeps them involved, and it doesn't just throw them to the wolves in terms of not knowing what's going on in rural practice. And so that's the extent of my research.
You have to do it again.
Oh,
Wow. This is now maybe.
that was
Does anyone have questions?
well done and well said. Ann, go ahead.
Oh no, I just wanted to
Are you
ask
teaching?
questions before I take credit for all my students' work. So, but seriously, this actually is the moment where I get to take credit for it, as well as John Lambris, who I think is on. John, are you on the line?
No.
Maybe not. I thought I saw his name.
Laura's here, and Carson, we're all in the room here.
Yeah, John deserves credit partly for inspiring these students, because many of them have worked with John in other classes, and so it's what brought them sort of out of the woodwork to me on this project. But then John has also been involved sort of at various points all along, and sort of just mentoring the students and helping them with their research and inspiring them. So we're grateful for that. And then I also wanted to just congratulate Zach is not going to the rurals exactly, but he's moving north, which is exciting. He's going to be clerking in Carson starting in August, I guess. I don't know when it's starting, but so he'll have much closer exposure. So thank you, Zach. That was amazing. Thank you, Amanda, and thank you, Misha. You guys did a really great job. I'm sure your colleagues feel like they were well represented. And
I
if
think
anyone
you got Christie's on there too, though. I think.
Yes.
Was it Christy?
Yes, and Christy and Aiden and Grace all contributed, but we're willing to sort of cede the stage to Zach and Misha and Amanda for today. So thank you so much.
Very good. And for each of you, we have, this is the first certificate issued by the Board of Indigent Defense, and it looks like this. So you can, who's ever doing the virtual, getting the virtual certificate, we're going to get the hand-delivered certificate down in. But it says, Department of Indigent Defense presents a certificate of appreciation to Amanda and the rest for all your hard work and research and assistance in developing department regulations signed by the chairman, dated today. We can't say enough good things about you young folks, you young students and soon to be lawyers and professionals out in making our state move. You're doing something. I know Ann probably tells you this all the time, but this is from my heart. What you're doing is preserving democracy. And if I could be a little bit out there a little bit, I'll tell you, I think our democracy in this world is under attack. And seeing folks like you come and talk about the Constitution, talk about, what we need to do to get people involved and get taken care of out in the rural communities where they really don't have a whole lot of amenities like some of us do in other areas. Congratulations to you. Go work hard. And, I can go home tonight and say I'm an old guy, but we're in good hands. So, and Zachary, when you get to Carson City, I expect you to come see me. If you don't, I'm going to have the sheriff out after you because he's a good friend of mine.
I'll be sure to come see you.
All right. Who are you going to clerk for?
Judge
Who are you
Gibbons.
clerking for?
Judge
Who?
Michael P. Gibbons. Gibbons.
Okay. All right. All right. Up in the high tower of the ivory tower. All right. Where are we going now?
Update on department discussions with the counties.
The students, you're welcome to sit in and listen to all this if you'd like to do that. But now I'm going to turn her over to Marcy. She's going to give us an update here.
Thank you.
Actually, Patrick wanted to give a quick update of what we've reached out for.
Chairperson Crowell, ladies and gentlemen of the board, this is Patrick McGinnis, Deputy Director. At our last board meeting, we had made contact with 3 counties, the stakeholders in Pershing, Humboldt, and Lander. Our goal prior to this board meeting was to meet and greet the remaining stakeholders in the counties. Unfortunately, we weren't able to do that in person, so we navigated through this remote meeting instead of teleconference meetings, and we met with all the stakeholders that we set meetings with throughout all the rest of the counties, and we discussed our proposed regulations, gave them some ideas on where we're going with our regulations, the rulemaking process, answered any questions they had, and our next anticipation, or our next goal is to meet with all of the commission chair for each county, provide them with an update on where we're going.
Wow, okay.
And I think following that up, in reading NRS 260.070, each Board of County Commissioners of each county is required to do an annual report on or before May 1st of each year. We've reached out to every county, however, we've only received reports from Eureka, Lincoln, Washoe, Carson, Elko, and Lyon, and I am requesting permission to extend the deadline of the on or before May 1st to on or before June 1st.
This is Joni Eastley. Did you get any feedback from the counties who failed to report as to why they failed to report?
Joni, this is Jeff Wells. I can answer that for Clark. The answer is we haven't finished our budget yet, and what she wants is fiscal year 21's budget. And
Got
as
it.
you know,
Okay.
Joni, the statute.
Yeah, that's right.
And in fact,
Yeah.
the statute, I pulled it because we're talking about BDRs later, and we probably should put the change into BDR. NRS 354.596 provides that the counties shall submit their budget to the state not sooner than the 3rd Monday in May and not later than the end of May. So I would recommend that not even asking for June 1st is good enough, because that only gives people 1 day to get it to you. I would pick June 15th so that the counties who get it done on May 31st then have a couple of weeks to send it in. But that's why they haven't gotten it, because I haven't gotten it to send to you yet.
Okay. Well,
Sounds
And we
perfectly
have
reasonable.
received responses. This is Marcy. We have received responses from several of the counties. I know Nye County is working on getting their response completed, and we will be reaching out to the rest of the counties just to follow up if they need additional time or assistance, because we are available for that.
okay. What else we got to do?
So I don't know if we could have a motion to extend that deadline to
keep that as
June
a meeting?
15th or June 1st.
Yeah, let me ask Jeff. Jeff, how big of a problem is that? I mean, from a public policy standpoint, you know, not just us here in the Indigent Defense Board or the rurals, how big of an issue is it to move the 15 days, move 15 days? Does that fit all the state or not? I mean, I think, you know, when we start presenting legislation, we've got to have a public policy behind it. Does it apply to all of us, I think?
Well, the statute applies to all of us, yes. And that's why I was recommending moving it to June. I don't know what the practices are in all of our counties. But Clark County's normal practice is to do it actually on the very first date. We normally have a special meeting on the 3rd Monday of May, pass our final budget. And so normally speaking, we could do that right after that and still make her June 1st date. The only reason I brought up the fact we might delay it till June 15th is I'm unaware if the other counties actually do it at the earliest date or if they wait till the last date, which is May, the end of May.
I don't know, but I suspect I know the answer to that. So now I got it. Let's take a motion then. Everybody okay with doing a motion that we, pick up talk about a bill draft, to present a bill draft that would extend the time for transmitting the financial budget information to the Indigent Defense Board? Well, it would be transmission of the budget period, is done by June 15th. Is that right, Jeff?
Yes, sir.
Words to that effect?
Yes, sir.
Chairman Krell, this is Lorinda Wickman.
Hi,
I
Lorinda.
would offer up a, hi, how you doing, Bob? I would offer up that motion, but I'd like to extend that to the end of June.
I
End of
concur
June?
with that, Lorinda. I agree with that. In fact, I was going to recommend July 1st.
Yeah, July 1st would be perfect, and I just know what our staff has. Yeah.
If we extend it out from the 15th to, and this may be getting too far into the weeds at this juncture, but if we extend it out there, are we stepping on anybody else's toes? Like,
I don't know whose toes we would be. I don't know whose toes we would be stepping on by giving them more time. I just can't imagine it, Bob. But if someone has a problem with that, I'm sure we'll hear about it.
All right, so let's take a motion. Who made it?
I will.
Jody, did
I
you
would
make
like
the
to
motion
make.
extend it? Yeah, make a motion, somebody, please.
Commissioner Wickman did.
This is
Okay.
Commissioner Wickman. Do you want me to repeat it? I'd like to make a motion
Yeah,
to
repeat it so we
extend the
know.
deadline. To extend the deadline to July 1, and
Okay.
I'll
to
second.
also include that as work for a BDR to change the NRS 260.
Okay.
I'll second her motion. This is Joni
I don't
Easley.
think, I don't think we should make that a separate BDR, just to put it as part of the BDR that we're going to be submitting.
That works
right.
for me.
And,
That's fine.
and this is Marcy, if I could just comment on one issue pursuant to NRS 180.410, subsection 2, our department is required to file an annual reporting on the status of indigent defense in Nevada on July 1st. So if we extend the deadline to July 1st, that information will not be contained within that report. And that report goes to the Supreme Court, the governor, and the LCD.
Okay, Bob, we finally heard our first problem with it.
Yeah, well, I guess, you know, what's that say then? You want to extend it out to July 15th then?
The deadline
Or
for us,
July 10th?
our reporting
No.
deadline?
Oh, no, that's all right.
No,
So,
their
I'm missing what you're saying there then.
Well, then
Go
the
ahead.
other choice would be go back to my June 15th date, and then Marcy could still make her July 1st date.
Commissioner Wickman,
I
I'll
will-
amend my second if you want to amend your motion.
I will amend my motion. Yes, thank you. This is Lorinda.
All right, there's a motion to extend the financial reporting of the budget to June 15th. There's a motion by Lorinda and a second by Joni.
Yeah,
Any further discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Passes unanimous. Okay, thank you very much. All right, now where are you?
I just wanted to update everyone on what's going on with our IFC request. We were able to get all of our requests that we set forth. The first request was permission to contract with Legal Server or funds for a legal server. At this point in time, we are working on a solicitation waiver with state purchasing to see if we can just contract with them or if we need to set this out for bid. We may have to set this out for bid, so I'm requesting permission to either contract with Legal Server if that solicitation waiver is granted, or if we're able to jump on another agency's contract. Apparently, if another state has a contract with Legal Server, we can also jump onto that contract. Or if that is not granted, to request permission to issue a request for proposals for software program. So that's what we're working on at this point in time. We're trying to get that contract done with Legal Server if we're allowed to go with the solicitation waiver or just a direct contract through another state. The second I wanted to update you with is we did issue the RFP for the Delphi study. That was already issued on May 1st of 2020. With the fact that that was issued, We should be able to enter into a contract by August Board of Examiners. We're also requesting permission to send out an RFP to recruit a data analyst. What we're looking for in this data analyst is possibly a fiscal data analyst to help us with some of the fiscal notes on the BDRs that we are setting forth, and possibly some other issues regarding setting up different programs throughout rural Nevada. So we are going to be issuing an RFP. We're trying to get it done by the 15th, and that'll set us up for September BOE. So we're actively working on those 3 items.
Okay. Let me say this. I don't know how many of you heard our folks present at IFC, particularly Marcy. I did. I got to tell you, that was really professionally well done. I mean, I was not that I always didn't know that they're bright people we have working with us here, but that's one of the best presentations I've seen over at IFC, and so hats off to you. The board ought to know that you're in good hands over there. Good hands. So do we need to do anything on Davis versus State now?
I am requesting authorization for Chairman Kroll to sign Appendix A of Davis v. State. I have shared with all of the board members a copy of the settlement agreement. Craig Newby is also available if you would like to ask him any questions. And we also have Appendix A available for the mayor to sign, or the chairman to sign. I do have a PowerPoint presentation which I've provided to you, or we can just go over what the requirements are going to be of the board if Chairman Kroll signs this. First of all, workload data reporting is going to be required to commence on May 1st of 2020. So that deadline has already passed, but our understanding is that the ACLU as well as Mr. Newby are aware that we do not have our legal server or software in place, but that we are just supposed to start accepting reporting as it currently is. It will require an annual report on the status of indigent defense in Nevada. That's already a requirement in NRS 180.410. It'll require us to establish a standardized contract for indigent defense within 6 months. We have a contract that we've proposed to you, although we cannot have any sort of action on it today because we need the regulations to pass, but these are things we are actively working on them. All new county contracts for indigent defense must be approved by the executive director prior to execution within 6 months. All class members must have immediate access to applications for indigent defense within 6 months. This will be a proposed regulation once we receive those regulations back and have our workshop. Another is all class members must be screened for indigency within 48 hours. This is a proposed regulation that we will present to you when we have our workshop. All class members eligible for publicly funded legal representation must be represented by counsel at initial appearance and arraignment. This will be a proposed regulation. Defendant shall establish a system for issuing client surveys to indigent defendants and incorporating that feedback into the responsibility for reviewing the manner in which indigent defense services are provided. That needs to be done within 12 months. We are adding that requirement into the RFP for our data analyst to see if that's something that the data analyst can assist with. The Delphi study contract must be executed with the qualified provider within 12 months. We have our RFP out at this point in time, and we think we'll have a contract executed sometime by August. The Delphi study standards must be included in that indigent defense contract within 6 months after the Delphi study, and we intend to do that. Compliance with Delphi study workload standards within 12 months after Delphi, and additional requirements are to provide a training. This is the 4th request that we had approved in IFC. We received almost $20,000 to be able to put on a training and assist with per diem travel costs. We will be required to have a monitor that will monitor what the board and department are doing and whether they're complying with what is set forth in Davis. And then finally, in that July report, we must include analysis of whether certain statutes are inconsistent with AB 81, and those are specifically NRS 7.115 to NRS 7.175 and NRS 171.188. And you will see when we go into our BDR recommendations, we do recommend changing those statutes consistently with what the ACLU is asking us to look over those statutes to determine whether or not they create economic disincentives, and if they do, whether or not we should recommend that those items be changed. And we are recommending that we go forward with the BDRs on those statutes today. So we are requesting permission to allow Chairman Kroll to sign that appendix.
Okay. Hey, Craig? Craig? I've already signed it. What do you want me to do with it? I'm kidding.
Have Marcy send it to me, assuming that your board is good with you signing it.
For all of us, though, I think we need a motion to allow me to sign. And has everybody had a chance to read Appendix A?
Yes.
Do you want me to read the paragraph on it? Do I need to do that?
Sure.
I think I will, just so we know what we're signing here. It says, pursuant to AB 81, the Board of Indigent Defense Services has the authority to act in pursuit of its statutory responsibility to make efforts to improve the quality of mandated legal representation in the state of Nevada. The board has reviewed the consent judgment settling the Davis versus Nevada lawsuit and the state's obligations contained therein that are expressly intended for implementation by the board, the Department of Indigent Defense Services, and/or the executive director or their designee. The board acknowledges that those obligations constitute measures that, once implemented, will improve the quality of indigent defense services. Therefore, the board hereby authorizes and directs the executive director and the department to implement those obligations in accordance with the terms of the consent judgment. The board represents and warrants that it has authority to take this action. That's what we're signing today. Anybody have any objections to that?
I have questions, at least, if I may.
Sure.
I'm hoping that Franny is on the phone, and I see Craig's there, because I don't want anybody to think my comments are intended to derail the 1,000 hours they put in to move this forward. I do have concern on one aspect, and that aspect is comes under the category for workload. And it's on page 17, I think, of the consent decree. And it basically says that the workload standards as done by our Delphi study shall be put into these contracts. It allows this board to create standards that are equal to or more strenuous, but that has effectively taken away a huge portion of the work of this board. One of the things that this board was charged to do was to create workload standards. And if we turn around and we hand it off to whoever our contractor is, and we are stuck with whatever the contractor comes back with, even if as a unanimous group we disagree with some premise that they have come up with, we are powerless under this consent decree to change it. And that's what I'm concerned about.
Craig, you want to answer that?
Well, Jeff, I'll jump in here. I mean, I think the starting point on this is, as part of the discussions that have taken place, which I'm not going to get into the specifics of because we had closed sessions talking about those, and I've been working with your board chair and with your executive director throughout this process. This provision's been there from day one, and the understanding, and I don't want to go so far as to speak for the ACLU because I'm not them, and even Franny Forsman, to the extent she's here as a member of the public on the line, she's not the ACLU as well. But there's a general understanding that the best practices for coming up with a workload study is not a board, no matter how good a board is or isn't, to determine what a workload standard is. It is by going through this Delphi process. And that was one of the basis behind which the goal was to do this through that process. This is one of the first things in terms of the department's thinking, in terms of my conversations with them, they thought they need to do to have standards by which this board can judge whether these standards are being met or not. And I would submit, to the extent that there are close calls associated with whatever these workload standards end up being, this board's going to have discretion to say, well, what do we do about it if someone's not meeting a standard or not? I think the default should be someone's not meeting a standard, but those are getting into policy questions. I do think, but if there's close calls in terms of does this properly apply or not, I think there's room for this board to be involved. And I think that also the question also assumes that the board wouldn't be part of the Delphi study process in the first place in terms of being conferred with, along with all the other stakeholders involved that go into a Delphi study, which Marcy can describe in a little better detail than I as the subject matter expert. I think there's room for the board's participation on this as well. But this is certainly a workload study. The standard is that it's developed independently. It's not something that's developed by an appointed board or an elected board, generally, that from what we've seen in other states.
Chairman Kroll? Yes, I'm on the phone, Chairman Kroll. Thank you. I agree with Craig. I don't represent the ACLU, but I do represent the class. So I agree with his interpretation. I think it might help your board to hear from Marcy on the description of the study itself, because not everybody is familiar with those.
Drew, I see you going to your microphone. You got anything? Drew? Okay.
Well, and for a description of the study, we have issued an RFP, but we haven't contracted with any agency yet. What we are expecting, or what we've seen, is that we would use the software program for individuals that are actually practicing law and providing indigent defense services through the rural, would be submitting their timesheets and describing how long each case generally takes. We would be asking that all members that are providing services throughout the world participate, because we want to make sure that we encapsulate all types of cases. Sometimes in the rural, murder cases don't necessarily happen that often, and that's why it's necessary for every provider to be participating in our study. They make their report as to how long it takes generally to be able to complete these cases. Then in a Delphi study, they put together a panel of experts, and the panel of experts look at what was done, or look at the type of case, and they make a determination as to how much they think, or how much time they think the case should take. And then finally, I believe that the research or the data analysts put together what was reported by the indigent defense service providers as well as the experts to make their recommendations for workload studies.
Franny? Anything else?
Nothing more for me. I think again, as Craig described it, the reason it's phrased that way is to provide some independence. It's not complete independence, because you as a board will oversee compliance issues. So that's where you will jump back in and go, well, it was to just separate a bit this issue of workload, because for people who are trying to make budgets and who are looking at the money part of it, they wanted to be able to have the workload determined independently.
Okay. Jeff, what do you think? Jeff Wells.
Well, I understand what their goal is. And I recognize why it was going to be difficult for us as a board to vary very much off of any standard that this group would come up with in any event. I'm just not sure that, the legislature delegated to this board a duty. It says right in AB 81 that we shall establish guidelines to be used to determine the maximum caseload. Well, what we are now saying is, despite the fact that the legislature delegated it to this board, we are now going to go delegate it to whoever we put under this contract to make that study. And I mean, to be literal, let's say they come back and it says you should do 150 cases if they do cases, or that you should spend no more than X number of hours on X type of case. We couldn't even vary that by 2 minutes. Now, later on, to come back and say that we get to decide whether somebody is complying or not, I mean, that's real simple. If it's a raw caseload number and somebody has 151 cases and the number is 150, well, then they're not complying. So I'm not trying to screw up the settlement. I know they've worked very hard on it. I would have preferred that language simply say that we have within 6 months after we get the results back from the Delphi study, we have to put it in the contract, that it has to be substantially similar or some phrasing like that. But to say it's exactly their way unless we make it even stronger, to me, takes all the judgment out of the board, and it was the legislature that delegated it to the board. Rightly or wrongly, and best practice or not best practice, we just changed the statute.
I guess I'm having difficulty seeing that one, Jeff. Help me understand. We're allowed under AB 81, I think, to contract with people to help us draft these regulations.
Oh, and we absolutely should.
Then the next question is whether or not we have to adopt those standards, whatever they may be.
Well, and Bob, that's actually all I'm saying. We absolutely should contract with somebody to do all that work. I agree with Craig. We shouldn't be doing it. We should contract with somebody to do it. But our state tried that 2 or 3 years ago, and there was a couple of assumptions in that thing that were just demonstrated to be incorrect. Ultimately, when it was presented to our Supreme Court, they rejected that study. Now, I wouldn't know that couldn't happen again, but what this settlement says is we're going to get the experts out here to help us, which we should do, but no matter what they say, we now have to adopt it unless we want to be stronger than what they have. And I just don't particularly like that provision. I'm not saying we shouldn't say it has to be done within the time period. It shouldn't. I'm not trying to not hire them. It's a fairly minor thing. But if it's only stuck to the rural counties, I probably shouldn't have bothered to talk about it. But
I guess I'm curious, Jeff, how would you feel about something that just breaks up the process but is essentially functionally the same? You kind of mentioned this idea, like, for example, that the Delphi study would go into effect, at this time, right after, absent something by the board, right? Like, to kind of make it automatic, but still have it, still give it to the board in order to do it.
And I totally agree with that, hiring the Delphi folks. I totally agree with the time limits that this settlement has come up with that it should be implemented by. I think it's only really the one sentence that bothers me, that it says they're only saying in the settlement that we get to disregard the things only if we want to make them equal or more strict than whatever these standards are. We couldn't even budge 1 ounce in the other direction. I don't know. It's just, anyhow, Craig, if you think that's going to kill the whole thing, then just let somebody else pass it. I'm just making an observation that I
guess
think
one of the questions I'm worried that you're raising, though, is just whether it's subject to challenge by others as being, an unlawful delegation of legislative duty.
Well, yes.
I assume that was a question for me, Professor. I don't know the answer to that standing here today. I think addressing Jeff's questions, there's 2 ways, there's two thoughts I initially have about that. One, for this to be an effective Delphi study, there's going to be a significant involvement by this department and this board to make it happen. So hopefully that the mistakes that happened with the prior attempt that happened on this 3 or 4 years ago don't happen in this, that many of us were involved with, Ms. Forsman is aware of as well, witnessing and seeing, and we don't have that type of issue. Two, as a blunt level to the extent this board does have, the settlement says what it says, and if there's a decision at some point that the board is not going to comply in a hypothetical situation with Jeff's hypothetical extreme unwarranted workload requirement, then I get to wear my suit that I'm wearing in my house right now, and I get to go to the First Judicial Court, and I get to try to explain, notwithstanding what the settlement agreement says, why we're trying to do something that's slightly more reasonable. And there are dispute resolution provisions within this settlement, and if something were to go that far off kilter, there's room to try to go through dispute resolution to fix it ultimately with the judge. And we can do that. I don't think we're going to end up in that situation. We're entering
Can you
into.
hold off 1 minute? The chairman is looking up at the law. Can you hold on 1 second?
Just 1 second.
I'll hold on.
I'm sorry, folks. Jeff, what I was looking at was AB 81, and that clearly gives the board the authority to adopt regulations establishing standards for the provision of indigent defense services, including without limitation, requiring indigent defense attorneys to track their time, yada, yada, establishing standards to ensure that attorneys who provide indigent defense services track and report information in a uniform manner, establish guidelines to be used to determine the maximum caseloads for provide indigent defense services. I guess, and Craig, maybe this was for you. I mean, if what Jeff is saying, maybe I should say it like this. I mean, to me, the legal argument is whether or not the contract supersedes, the settlement agreement supersedes AB 81. I don't think you can do that.
I don't think it's the intent of the settlement to supersede AB 1, but it's certainly, there are requirements under AB 81, and then this is a settlement between the state, specifically Governor Sisolak, and the plaintiffs in this case to resolve a class action lawsuit. We certainly can impose additional requirements above and beyond statute to the extent the parties are amenable.
Hang on one second. Okay, the acknowledgement we're asked to sign on Appendix A also has this language in it. The board has reviewed the consent judgment settling Davis versus Nevada, settling the Davis versus Nevada lawsuit and the state's obligations contained therein that are expressly intended for implementation by the board. Doesn't say by anybody else. So that's what I get. I mean, the argument I'd make, Jeff, is that if you go down your argument too far, what we're really saying is that the settlement agreement supersedes state law, AB 81. I think I'd make that argument. I mean, I would make the other argument that, you know, the settlement agreement cannot change state law. That's my 2 cents. Yeah. I'm retired.
Well, and
how about
again,
how about one of the students? What do you guys want to weigh in on? They're all quiet. You know what? All right.
They're smart. They're smart students.
All right, smart students. All right. Well, you know, what do we want to do then, Jeff? I mean, I don't want to necessarily, and I know you don't either, blow up a settlement agreement.
I don't. I would have raised this way back when the negotiations were going on with them. Had I seen it back then, I'm not trying to cause the settlement to be messed up. By the same token, I'm worried based on past experience, and even though Craig assures us that it'll be better this time, I'm worried by past experience that the workload standard that comes out won't be very good. And I have reasons for that, all timing with the timing of when we're doing it now tied to how the old normal has been replaced by a new normal, and who knows what we're going to get to when we start tracking people to keep track of how long they spend on working on cases when we don't even have cases going forward to trial at the moment. There's a whole lot of those kind of issues, and so I was just trying to make an observation that we have punted our entire authority to make this decision to whoever we hire as the expert.
Okay.
Chairman Kroll.
Yes,
Chairman
who
Kroll.
is that?
This is Lorinda.
Hi,
It
Lorinda.
also occurs to me. Hi. It also occurs to me, listening to Jeff, that if their caseloads are too strict and the state doesn't pay, then the counties are still. You get what I'm talking about? Money. It boils down to money. Okay.
So what you're saying is that Lorinda, you're worried that the standards are going to come down too strict. We can't do anything about it. Is that where you're coming from?
Lorinda, if I can add to what you said, this is something we've been saying for many, many years, and that is that a one-size-fits-all solution is never going to fit the rurals.
It won't, because like I said, if what Jeff said is true, and we have to accept whatever Delphi comes down with, and Delphi, if they come up with something that is too strict of a guideline, and the state refuses to pay for this, to pay for those caseloads, whatever the number might be, then the counties are still left holding the bag on something that's a requirement of the state.
Mr. Chairman?
Thank you.
This is Julie Kavanaugh-Bill. So I just want to make sure I'm clear. We're looking at the last two events in the chart of deadlines in the settlement agreement. Where the study standards. Well, the last one is compliance with Delphi study.
Where are you, Julie?
I'm in the settlement.
Yeah. I got you.
Draft at page 9.
Yeah.
Line 10 through 4. Those changes last two events.
I got you.
So if that's the concern that's being raised, and I also don't want to disrupt the settlement from finalization, but in order to be in compliance with the statute where we're not delegating unduly our authority to this contractor, would it be possible just to add a clause after that as approved by the board? So compliance with Delphi study workload standards as approved by the Department of the Board of Indigent Defense.
I like that.
That gives us the opportunity, once we get their standards, we can determine if we think that they're applicable, but we can show, pursuant to our legislative authority, that we contracted out kind of the workload, but then we didn't give up our final authority on it.
That works for me. This is Lorinda.
Yeah, I like that too.
Yeah, you know, guys, I think, folks, the difficulty with that is that's an interesting change. I mean, it's not very many words, but my own sense, and Craig Newby, you step in here, you know, is that change, I don't know what effect that causes at all in negotiations. I would just go back to what the statute says, and it says we have that authority. So I guess, you know, we could make that argument that we have the authority to put it in Appendix A, but my own sense is if they come back too hard, we're going to make our own standards, and then somebody's going to sue us, and we're going to say, well, this is what the law says we have to do. But then we've already signed the settlement agreement, so.
Well, so I'm looking, I admit I didn't have a copy of the most recent settlement agreement out. I was waiting for questions, and I wasn't expecting questions on this one, Jeff. But I'm looking at this paragraph, and it says, within 6 months of the study's completion, defendants through the board, which I would probably could say is not as artful as saying through the board's consideration and approval, but that's how I think is the most reasonable interpretation of that, to the extent I'm giving legal advice in a public meeting right now, shall include in the model contract reference above provisions to ensure that indigent defense proprietors' workloads, including any private work outside of indigent defense duties, are consistent. I see the word consistent with the standards established in the Delphi study. I don't see the word identical. I don't see the word copied. I don't see. I see consistent.
It's the next sentence.
These workload standards.
Can you guys? This is Julie.
And I'm going to keep going. I know it's the next sentence, but you know, to the extent that the sentence I just read described these workload standards, and ultimately, without having us to try to go into emergency closed session, I am the one that will have to be going to court to explain what this means if I ever have a fight about this with Ms. Forsman's clients or things of that sort. So I'm trying to work through a reading that's reasonable right now. These workload standards, which I would say refer back to the last paragraph, if it had been written a little better, if you had a little better settlement conference attorney drafter than perhaps me, maybe would have been slightly more specific, may be superseded by standards of equal or greater rigor promulgated by the board and or department. If I was forced to have to argue about these provisions, I would argue if something was way out of, I mean, we have two scenarios. We have one where the Delphi study is way off track. And if it's way off track, the board has its discretion to comply with the settlement or not, and argue why it shouldn't and why there shouldn't be consequences for it. Weird things happen. We are in COVID-19 at the moment. People are making weird arguments in court of things that are completely unexpected. If it's the board taking consideration in terms of making the Delphi standards consistent, by making it consistent and addressing county differences and things like that, or working in terms of the Delphi consultant presenting whatever this report's going to be before it's finalized and ultimately approved as part of this, I think if it's a narrow type of difference, I think the board has discretion to work through it. And so I'm happy to go and discuss with opposing counsel if there needs to be a change along the lines that was said, which there's been a lot of talking back and forth. I don't have it written down yet. I'm happy to go back and put in where is this as approved by the board language want to be added? What's the proposal? So I can, if I'm instructed to go back, I can attempt to go back.
This is Julie, Mr. Chairman, if I may.
Yeah, go ahead.
So, Craig, I can see where you're reading on page 17 of the stipulated consent judgment.
Mm-hmm.
So I would add it on line 14.
Mm-hmm.
It says consistent with the standards established in the Delphi study, and I would add "and as approved by the board." But then you're going to have to change that language in the next sentence, or just remove that language. So you could remove the sentence that Jeff's having concerns about.
If you make the change on line 14, I don't think you can take out the lines 15 through 16, 15 and 16, because they don't make sense with that.
Right, I think you'd have to remove that. This is Julie again.
Well, Craig, how big of a deal is it to go back and see if we can add those three words to line 14 and take out that one sentence?
I don't know the answer to that sitting here, standing here right now.
Can I ask a question, Mr. Chairman?
Go ahead.
So I guess I wanted to just play out a little bit more the language as is in terms of how it would work out in sort of playing a little bit, Craig, with what you had suggested, like what's going to happen. So it seems like that might be useful so that we understand sort of just the relationship between the potential of triggering a lawsuit reaction, right, in terms of not making the ACLU happy versus perhaps being between getting a challenge from the counties, for example. So doesn't it seem to, and maybe Craig, you could jump in, but it seems to me that scenario one, the one that's contemplated by the agreement, is that we have input into the Delphi study. The Delphi study comes back and the Delphi study is good. We all go with that and everyone is happy. And it may be understood in that scenario that the Delphi study comes back and within 6 months we are doing something, and so that is our execution of the duty under the statute. So that's easy scenario. That's like the easy scenario where everyone's happy. Then the next would be that the Delphi study comes back. It's so stringent that someone is balking, right? Saying, we can't do this for whatever reason. And so the board wants to make an adjustment to the Delphi study. If the board does that, the board has discharged its duty under the statute, so we don't have that problem. We just might have a lawsuit problem with the ACLU, which maybe the ACLU will, given the circumstances, be, and our duty, because we're doing our job, will be satisfied that this doesn't trigger some more consequences because they understand and are in agreement with what happened because we sort of are all acting in good faith. But we have discharged our duty under the statute, it seems. And then, so I'm trying to think of that, then what happens where, so I guess the other thing would be, the other scenario is the Delphi study comes back, the board adopts it, and then one of the counties is suing us for saying you've not complied with the statute. I'm just trying to think of what the scenarios are and whether the existing language in terms of how it would play out means that we've done our duty under the statute. And if there's irregularities, we're going to take a risk that ACLU is going to be able to go into court to challenge it, but possibly not if we're doing what we're supposed to be doing. That's not a risk. It's just that their leverage is that they don't they have the ability to go in and challenge standards that are substandard in their view. So I don't know, Craig, if you could respond to that, just in terms of, we realize that the language as is the easiest option, and I'm trying to flesh out what the real potential problems are in terms of our duty as boards, as the board.
I really wish we would have had a closed session. This would be a little easier for me brainstorming than a public meeting, and helping law students relive the Socratic method, so to speak, happily safe at home. And so, I mean, in the second, there are enforcement provisions in the settlement agreement, skipping to 2, because one's everything's happy, we all dance around, you never see me again, that's great. You don't see me for this purpose anyway. And scenario 2, to my mind, there's a process for the state to go from where it is now, which is we finally have AB 81, we finally have an executive director, we finally have a board, we're finally going to be able to go after this initial IFC request, notwithstanding the exigent circumstances in the world, this department's going to be able to participate in the 2021 legislative appropriations process. These are starting points, and this is a consent judgment that's designed to allow the state, if and when it can demonstrate compliance with the requirements of this, but no sooner than summer 2023, once we're able to demonstrate compliance with these various factors, we're going to be able to seek release from the consent judgment, and this is going to be a department just like every other state department run by Marcy or whoever may succeed her in the long future and what have you. So that is so in the time period between the state is out from the settlement and everything is successful, whether it takes 2.5 years from now, 3 years from now, or whether it may take a little longer given the state's economic woes, I don't know, but there's going to be a process in terms of this department on the ground demonstrating good faith and reasonableness in moving this process forward. And one step in terms of the reasonableness type of thing, in terms of moving this process forward, might be, wow, the Delphi study went sideways, which is your scenario number 2. Or it might be, I believe it was Jody's scenario in one of her prior comments, which is the state's going to do a requirement, but the counties aren't going to have resources immediately to implement it. Notwithstanding the structure of AB 81 to allow this board to ensure that money is directed to the counties to do this, there's no money, period. That's a question of timing in terms of when the settlement is fully performed, but it's not, it comes down to reasonableness on that. I mean, I think the scenario that I imagine, without having someone that's with the ACLU on the phone call, but I imagine they would have concerns over having a rural county take this settlement agreement and attempt to undo it on the basis of somehow it violates what was passed by the legislature in AB 81. I imagine the ACLU would be pretty concerned about that, and I imagine, without having talked to them, that they would be amenable to that type of revision to allow them to have greater certainty that this is going to be done. Now, I will say this out loud, and I'm not your counsel, I'm counsel for a different client. If this board were to decide not to approve Delphi studies just because they thought they were too hard, or on some basis it's not reasonable, there will be legal consequences if we're in a settlement agreement revised like this. What exactly they would be in terms of, at minimum, me having to go in the First Judicial District Court and go to Judge Wilson and explain what this board was doing or not doing. That's my job, and I will do that. There could be other consequences under, if it's some sort of like a bad faith. We just don't want to do a Delphi standards. We think there's just there would be consequences.
Let me add, Craig.
To address number 3, so that the settlement agreement is rock solid from a county challenge. I understand the logic of that, and I think I can see the ACLU understanding the logic of it, especially with the reassurances of knowing if the Delphi is blown off entirely in some way, shape, or form, then there's an element of not good faith that's there that's going to happen one way or the other.
Okay.
So I hope that.
Craig, could I ask you to, and everybody on the phone call here, can I ask you to all turn to page 9 of the settlement agreement and look at paragraph 5, Charlie, dismissal?
Mm-hmm.
Okay, to me, that says the court retains jurisdiction on this until 2023.
At least until 2023, until we can demonstrate substantial compliance.
So, what do we have to do to demonstrate substantial compliance?
I think that we've done most of these things, and I think that we've done the things that are set forth in this agreement, which your department, as part of the process of working with the department when negotiating this agreement without revealing anything that's attorney-client privilege, my emphasis was to the extent that there was such a close overlap between what the department intended to do and or was charged to do associated with Assembly Bill 81 versus what was desired by the Davis plaintiffs as part of resolution in this case, my actions and my communications, both with this board, the department, have all been aimed at making sure the department has room to do what it's supposed to be doing anyway. And I think this agreement generally reflects that.
Mayor?
All right. Yeah, hang on, I got somebody up here too, so.
Go ahead.
Laura Fitzsimmons wants to chat for a minute.
I just want to observe a couple of things. Jeff, I think obviously your point's well taken it's well taken practically as well as in a vacuum. But if we look at the history of AB 81 and we look at the concerns that have been articulated in this meeting by our rural board members, I don't see it as a problem because as Jeff and I think we've all recognized, we don't have the expertise to do this study. We have the expertise to put Nevada's imprint on the study, but we're hiring experts to do caseload studies, right? Because we can't do it. So they come back and let's just say, they say a contract attorney in Nye County can't have more than 30 felonies in a year. And it turns out that, are they going to have to hire another contract lawyer? It turns out that that's going to cost Nye County money, right? Well, Nye County's not going to spend the money under the law because they have the baseline. So there's not an aggrieved party here. The state, as we have all said, those of us who have served in various iterations on this effort, this is the state's responsibility. So if there is an expert that knows what they're doing and they come with a caseload study that really requires additional funding for some county for indigent defense, the state's going to pay for that. The state is the party to this lawsuit. And Craig, as you mentioned, we're not your client. I get that, but in terms of, bringing this to a point where we can all move forward, I think the chances of a study coming back that is so out, like you can never have more than one felony per lawyer, like worst case scenario. I mean, at that point we can, what's the chance of that happening? And at that point, we could probably, if we put it in the contract, reject the study. And then we have to go back and explain this is crazy. But if it's just the concern of the rural counties is the financial cost based on the rural counties' history with unfunded mandates, and we're so sympathetic to that, but I believe that danger has been alleviated by AB 81, and it's further alleviated by the state's execution of this settlement agreement.
Laura, I actually think I have a suggestion that'll get us through this at the moment. And I agree with what Laura just said. I think the likelihood of it coming back completely outrageous like that is not likely. I do think it is possible, however, that the study that comes back may be one that we as a board agree to, but we might decide we want to see it phased in over time as opposed to immediately implemented within 6 months, which is in the consent decree, etc. I think a method of perhaps avoiding this, allowing you to sign this thing today and moving us forward, would be we put in the RFP that we actually require the Delphi study to submit to us a draft for our consideration and review before they turn around and submit a final report. I think in using the language that Craig has pointed to, that could be tied to a final report, and that would give us the opportunity, if they only came back as one felony each, for us to go back and discuss with them why they've done that and maybe make an attempt before we get to the final. And I think in some fashion like that, we can avoid the horror story that I would be afraid of, and we get to the scenario that Professor Traum has suggested, which is they come up with a real reasonable one, we all think it's reasonable, and we move forward. It's an idea to maybe get us across the hurdle today and let Craig move on with his settlement.
Not a bad idea, actually. I don't know if we've got that in the RFP or not, but I think we can do that for certain.
That's correct. We have not entered into a contract. So with the RFP, individuals actually submit proposals to us, and we have a committee that will sit and choose who we are going to choose to hire for the Delphi study. When we enter into the contract, we can make that a requirement that prior to the final report that the board have one submitted for comment and that they take that into consideration. So we can enter that into the contract.
Chairman Kroll, this is Franny.
Yeah. Hi, Franny.
Yeah, when we did this in the federal system, that's exactly what happened. Is that when Rand did a workload study years ago with us, I think that is actually the common practice with one of these consultants is that they come back to whoever has let the contract with a draft. It's sort of like an audit. They come back to you with the draft, and you work with them on the draft before it's finalized. I think that's common practice.
Okay. Well,
so, Mr. Chairman, this is.
Yeah, go ahead.
This speaking? Is Julie again. So, Julie Kavanaugh Bill. So in our motion approving the authorization for you to sign Appendix A, do we want to include in that motion also the fact that the RFP to the Delphi study would include that language?
The RFP has been issued. The contract. It would be in the contract that we would add it.
The contract. So I think, if Lorinda and Joni are happy with it, I mean, we could take a motion that says we authorize the signing of the appendix by me for the board here, but that we also, consistent with that, we are going to insert in the contract we have with any provider, words to that effect, that any provider that, we retain authority to suggest changes, to go over it, however that language could work out. I'm sure there's standard language on it. But does that help at all, Lorinda or Joni? I mean, if
yes, I'm good with that.
Like that.
Yes. Yeah.
All right.
Chairman Kroll.
Motion on the floor already?
Yes. Yes, this is Lorinda.
Real quick, Chairman Kroll, this is Drew.
Hi, Drew.
Just a couple comments. What prevents us as the board, considering that there sounds like there's several vendors that may reach out to take the contract, then ultimately the final product that we get we're not comfortable with from whatever point of view, what prevents us from going out and reaching out to a different vendor? Almost like get several sources. I don't know the mechanism behind what it takes to produce a Delphi study, but I know there's a number of organizations around the country that produce.
If we're unsatisfied with what we get back, we can do that. That's my belief, and in standard contracting practice, we don't have to accept it unless, because we're paying for it.
Sure. What about also the fact, because Joni and Loretta brought up, are we acknowledging with the Delphi study that there may be a discussion of workload that's different for each county around the state because they're so unique and different?
There has to be.
Right. So that whatever the product is not necessarily going to have this board vote on a one-size-fits-all, that the analysis would be county per county, and there may be some overlap of practice similarities, but there may be significant practice differences that our final responsibility may have a variety of different points on how each county should conduct their business. Does that make sense?
This is Franny again. I think that the intent was that the Delphi study would account for variations in the different counties because you've got all kinds of differences, including travel time. All of that will feed into any sort of assessment of workload.
Well,
I've been waiting for 12 years to hear that kind of language. Thank you.
Yeah, I either do not want to stall the momentum that we've received to this point, but I like the fact that we'll have the ability to, work with the vendor, whoever it is, to see kind of a rough draft and data collection kind of a discussions along the way.
My opinion, in my view, in my opinion, we have the authority to do that now.
All right.
It's a straight up contract.
Thank you. I'm good then.
Okay. All right. Who wants to, are we ready to try a motion on that? It's kind of a two-part motion. One, we authorize the signature of Appendix A, and two, we directing the executive director to put in the contract for this study that, how do you want to say that, Marcy?
Do you have similar language?
The existing language in the RFP requires that any proposal or contract for caseload standards for rural indigent defense providers that accounts for variation in counties and courts, variation in delivery models, and the variation in distance between courts and counties. To some extent, I think that language exists.
Okay, well, the language is there. We could just copy that into a contract. But go ahead.
And I think further for our, this is so ridiculous, further for our.
The governor opened us up.
Not the strip clubs. Anyhow, for our purposes and our comfort, I think if we just authorize the chair to sign Exhibit A, and if you want to link that, maybe first we say to make everybody comfortable before that motion's heard, that we are directing our executive director to include in the contract with the vendor that a draft of the Delphi study will be provided within adequate time under whatever the timelines of the settlement are, 30 days before, for the board's consideration and input. And okay, so that's A. So if that's the first motion, and then if that passes, then we're going to know if we vote to authorize the signature that Marcy's going to follow up.
Let me see that language that Jared just read.
Different.
Hang on a minute, folks. Just a minute. Is that in the RFP right now?
It is in the RFP, and it also says that we are able to negotiate the contract term.
Yes. Okay, well, here, the RFP that went out provides for variation in counties and courts. This is the Delphi study, provides for variation in the counties and courts, variation in delivery models, and a variation in distance between courts. That's in the request now, so we could make sure that that's there. I mean, that's kind of already, in my view, we've got that authority, but now it's clearly in print. So I don't care. I don't think it makes a whole lot of difference to us if we make it in one motion or two. but, Drew, you want to try a motion?
Sure.
Drew Christian? Try it.
Sure,
Let's see
Mayor.
where it goes. So move along.
I'll move for the chair to sign Appendix A, considering the language that's currently in the RFP of evaluations prior to a final report written.
Right.
I think that covers it.
I think that does it. I think that gets both sides, right? Okay, is there a second to that motion?
Well, Mr. Chairman, procedurally,
Yeah.
don't we already have a motion on the floor? Does the motion maker need to withdraw that motion?
I withdraw it.
Okay.
Procedurally, you're probably right, Joni. Did you make that motion?
Laura Fitzsimmons withdraws her motion.
She's back here with her.
Thank you, Laura.
Dress up. Well, thank you.
And
and
Mr.
Lorenzo
Chairman, this
for,
is,
Go.
Mr. Chairman, this is Julie Kavanaugh Bill. With regard to Drew's motion, I heard him say, to repeat the language in the RFP, but I did not hear included that the vendor needed to get us a draft for, I know Ms. Fitzsimmons just said consideration suggestion, but I think for our approval, something that makes sure that we still have that authority.
All right.
I'm comfortable.
I would ask that a friendly amendment be made to Mr. Christensen's motion to that effect.
And I'm comfortable with that amendment.
Who seconded Drew's motion? Anybody down there? I didn't hear that.
I'll second it. I don't think we had a second. This is Eastley. I'll second.
Joni, hi. Okay. On the motion, any further discussion? The maker of the motion accepts that change. And I think that the earlier motion was withdrawn by the maker of that. So there's a second to Mr. Christensen's motion, agree to make the motion, go along with the motion that was just announced that was sort of amended by Joni.
Yes.
Is the second okay with all that?
Yes, the second is good.
All right, just for the record. All right, on the motion, further discussion? Hearing none, all in favor, signify by saying aye.
Aye.
Aye. Opposed, nay? Nay? Okay, we're done. Okay, these kinds of discussions they're very helpful. I mean, they're very helpful for me. Maybe I'm just an oddball guy, but I like to hear all the stuff that's going on with this, so.
Can we clarify what's in the RFP? Just to clarify what's in the RFP, the project terms and conditions, 10.3.4, it is expressly understood and agreed that all work done by the contractor shall be subject to inspection and acceptance by the state.
Yeah.
10.3.4.2, any progress inspections and approval by the state of any item of work shall not forfeit the right of the state to require the correction of any faulty workmanship or material at any time during the course of the work and warranty period thereafter. And 10.3.4.3, nothing contained herein shall relieve the contractor of the responsibility for proper installation, maintenance of the work, materials, and equipment required until that's all been completed and accepted by the state. Perfect.
Everybody okay with that?
Yep.
Also, it's out in print. That's the RFP language. Okay. Do we have a motion on this? It's done, right?
Yes.
Okay. If anybody has to leave because of personal pressure, go ahead and leave, but we won't recess the meeting. That's one of the benefits of having a virtual meeting. All right, let's go on to the next item. Marcy?
Mr. Chairman, this is Ms. Kavanaugh Bill.
Yeah, hi, Julie. Yep. Go.
Do we need motions on 6A and 6C?
That's requesting the permission for me to move forward with the solicitation.
Well, we haven't really talked about, I think we touched on the data analyst. Marcy, it's up to you. I mean, what do you think?
I think we need motions. The director is requesting permission.
I agree.
Okay. All right.
I'll make the motion.
Motion's in order. Motion is in order. So who made it? Joni, is that who? Julie, okay.
No.
Is there a second?
It was Julie.
Is there a second to the motion? Yeah, I got it, Julie. Is
What
there a
was the
second?
motion, and which item are we voting on, A and C? Or
So just C, I think. C, correct?
I was moving for both A and C. Both
That's
A
all right.
and C. allowing the executive director permission to contract with the legal server if the solicitation waiver granted by state purchasing or request to issue the RFP for a software program, and as well allowing the executive director permission to send out the RFP to recruit a data analyst.
Okay.
And this is Marcy. Could I request that you add one more thing regarding 6A? If we are allowed to go through state purchasing to use another state's contract, then we would not have to issue a solicitation, and that's something we learned about pretty recently. So if that's an option too, I would ask permission to enter the contract that way. We're still working on this.
Use the states. Isn't that, I mean, we can cross the T's and dot the I's, that's fine. All right.
This is Julie. I'm fine with adding that to the motion.
All right. All right, Julie, make the motion again so we all know what it is, and we'll get a second.
Okay. I would move that we give permission to the executive director to contract with a legal server if the solicitation waiver is granted by state purchasing, or to work through another, was it department, Marcy?
With state purchasing to use another state's contract. Yes.
That's joint
Or
contract.
to use state purchasing. Yeah. Okay. And or to request to issue an RFP for the software program, and also to give permission to the executive director to send out an RFP to recruit a data analyst.
This is Lorenzo. I'll second that. I'll second it, Bob. This is Lorenzo.
Okay, Lorinda did. Okay, on the motion, discussion? I don't hear any, and I don't really see any. I don't know if I got anybody here. I don't hear any. So on the motion, all in favor, signify by saying aye. Aye.
Do we still have a quorum?
Nay?
Do we still have a quorum?
Sure we.
I think we do.
Would you like?
I don't think anybody's left, have they?
I don't know. Nobody's left. They might be on the phone.
I think Craig and one of my students left, but I think others,
Oh,
other
they don't
members are
vote.
still here.
Yes, they don't vote. Okay, thank you.
They better vote.
Okay. All right. On the motion, all in favor, signify by saying, once again, we do have, how many do we need for a quorum? 7?
7.
7?
So 1, 2, 3,
Okay.
4. Julie.
Got a quorum. Okay, we have a quorum. On the motion, all in favor, signify by saying aye.
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 Opposed, nay? Carried. Okay. Let's go on to the next one, Marcy.
Okay, the next thing that I was hoping to talk about were permission to submit bill draft requests to the budget office. I've provided you with the deadlines, and the timeline is coming up on May 20th of 2020. Non-budgetary bill draft reports are due to budget. Many of the proposals that I have would be considered non-budgetary, so that's why I'm requesting to submit these prior to May 20th. There are apparently 3 different types of bill draft requests: budget, which has a different deadline of September 1st to the budget division; policy substantive; or policy housekeeping. I'm able to submit bill draft requests over several different NRSs through one bill draft request. So that'll be our proposal today, is to issue the majority of these as policy substantive. And there is one bill draft request to, if it's approved, to bring all appeals and death penalty cases into the Nevada State Public Defender. That would likely be considered a budget bill draft request because it would cost more than $2,000 to implement and would be required to do a fiscal analysis note on that. I do have a PowerPoint, which I can put up. Would you prefer the PowerPoint, Chairman, or not?
We'll do what?
Would you prefer me to put the PowerPoint up?
Has everybody had a chance to read through all the suggested BDRs, bill draft requests? Do we need to put it up? Yeah, how hard is it to put up?
Pretty easy.
Let's put it up.
Okay. Getting to the right page. here. Oh, yeah, there we go.
This is Julie Kavanaugh Billigan, Mr. Chairman, if I may.
Sure. Yes.
Marcy, one question where the deadline was coming up May 20th. When would they actually go into effect? Because I know we'd still be working on our draft plan.
We select the date that we would like them to go into effect. We could have them go into effect immediately upon passage. I believe that there's also a July and an October possibility, but this would be done through the next legislature. So these would not be immediate. These would be submitted to the legislature for passing through usual session.
Thank you.
So the first bill draft requests that we are presenting here are in order to try and create some sort of independence from the judiciary. And this has been something that's been encouraged by the Sixth Amendment Center. We did speak with David Carroll, and he pointed out that it may be necessary or it may be a good idea to actually put a definition of appointments and a definition of selection. And right now when you read the NRSs, it only talks about the appointment of attorneys, but it's, and the selection generally is through the judiciary. This would create some sort of separation in that, where it would still be up to the judges to decide whether or not it's appropriate to appoint an attorney. And once that appointment is made, the selection would be a function of, and this would be a population break, if it's less than $100,000, what our proposed language would be, the department, and this is different than I sent out earlier, the department or their designee in the plan for the provision of indigent defense services. Or in counties with a population of more than 100,000, you would refer to the plan for the provision of indigent defense services to choose the defense counsel that will provide the representational services. So we are asking that we submit these to clarify appointment versus selection, just to make sure that it was clear the difference between the two. Moving on to what currently sets forth as the appointment under NRS 7.115, it talks about that how a magistrate, master, or district court judge can appoint an attorney, but once they decide to appoint an attorney, we talk about that if the public defender, which is generally the first person that gets the appointment, if they are disqualified due to a conflict, the court shall, after making a finding on the record of the conflict and the reason for the conflict, the court shall refer the selection of the new defense counsel to, and we have that same breakdown of if it's less than 100,000 to the department or to their designee, which is set forth in that plan for the provision of indigent defense services, or in counties with a population of more than 100,000 in compliance with the county's plan for the provision of indigent defense services. Moving forward to 7.125, the fees for appointed counsel.
Did somebody have a question? If you have a question, jump in.
This is Julie Kavanaugh Bill. On those first two, so on the selection versus the appointment, we've got department / the plan for provision of indigent defense services. And then we've got that same language then in 7.115 in the first subsection. So this has been a pretty hot topic out here in the rurals. I know that staff have met with, in particular, Judge Shirley, but I've had a lot of discussions with folks. And my understanding in reading the draft plan that you also provided, that the language in the draft plan actually would allow the district court judges to put forward panels of attorneys when the public defender is conflicted out. The department would then be able to review those proposed panels, and then those panels would go back to the district courts, and the district courts then, under pursuant to the plan, would in fact be making those selections or appointments from those department approved panels. Is that correct?
Well, in talking, I understand that what I sent out earlier did have a slash, but we did we did talk this through a little bit more, bringing up that point. And that's why we wanted to change the language to what's on the screen. I don't know if you can see it, but what we're changing
I
it
can't
to
see the
is,
screen.
okay, so what we're changing it to would be, let me go back, to the department or their designee in compliance with the plan for the provision of indigent defense services. So if we enter into a model plan, and maybe Jared can speak to this as well, but if we enter into a model plan and we specifically talk about how they would like to handle conflict and how they would like to go through selection on the list, if that met the board and the department requirements, then we could designate that to the counties to go forward how they feel is best. So that's something that we could build with the counties, and we could designate it if we felt that it met our requirements.
Okay, I guess my concern in moving, this is Julie again, in moving these two forward, is that we may get some kickback if we don't have the exact language of the plan proposed.
And I think that we did have some proposed language. By the time that these go before the legislature, most places should be in their model plans or model contracts at that point in time if we're complying with David. So this would be set forth. And these are simply bill draft requests, so they can be amended once it gets to the legislature. I'm just requesting permission to move these forward, but they can be modified by the legislature later on.
Okay, thank you.
Marcy, this is Jeff, and I'm not talking about that point. I have nothing on my screen. I'm wondering if anybody else has it on their screen, and I'm just doing something stupid.
No, it's not there.
It's all blue.
It might go to your view. If you select different views, you can select gallery view or speaker view. So if you choose speaker view, it should pop up.
How do you do that?
There should be like 3 little boxes, and then once you kind of hover over it, if you hover over who the person is in your left-hand corner, 3 smaller gray boxes should pop up that you can choose about different views.
I think that may be only available if you're leading the discussion.
I didn't hear that.
I don't know who was saying that.
It's Rob Tejas.
Oh,
Is there a kind of towards the lower left-hand corner of your screen, is there what appears to be a slide bar in blue and gray?
Yeah, I have one, but I can't.
It's all blue.
Might just happen there. In the materials, isn't it? Are you sharing your screen?
Yeah, I printed it out of the material, so I'm fine,
Okay. So the majority of these are in the materials. We did email them prior to the meeting, so if you want to pull up those PowerPoints, the only difference is that I did change the language. I took out the slash and I put or their designee.
I need to make sure that everybody knows where we are. If we can, not everybody's seeing it on the PowerPoint here, if we could refer to the printed document that was sent out. Does everybody have that with them? I mean, I
have both. This is Julie. I can see the screen now.
Rob?
I've got the PowerPoint on my screen, on my other screen, but separately opened. I don't know that I see it.
The slide bar worked. Thank you.
I'm fine.
The slide bar that I was referencing earlier, I can't remember which direction you move it, but it should shrink the video of our end of it and enlarge PowerPoint and vice versa, depending on the direction that you move it.
Should we proceed? Are we okay to
Yeah,
proceed?
proceed, go ahead. Is everybody up to, we got it all, either written or electronic version of that you could refer to? Everybody okay with that? Okay, go.
And in talking about these statutes, as we set forth in Davis, some of the requirements were to address certain statutes, and these are the statutes which Davis wants us to specifically address in our report in July. So the next recommendation that we have is under NRS 7.125, and we started off by crossing out subsections 2, 3, and 4 because those provided caps that you cannot, after you hit a certain amount of time, you had to file a motion for funds to be able to spend more time on a case. We believe that with the workload study that we will have, that cap will no longer be required because we'll know how long generally each case should be required to take for an attorney. And when they submit their bills, we'll be able to say whether or not they're far off that recommendation that's set forth in the workload, and we'll be able to take that into consideration later on in some statutes that we are proposing. So what we are doing is we are proposing that defense counsel, who is selected by the department designee, so this would be that same language, or in compliance with that provision of indigent plan for the provision of indigent defense services, if the population is less than 100,000, or in counties over 100,000 in compliance with their county's plan for the provision of indigent defense services, if they're appointed, then it just talks about how they get paid $125 per hour in cases where there's death penalty cases and $100 per hour in all other cases. So we do recommend removing the caps as Davis did propose. And then subsection 2, we are requesting that we cross out, but the total amount of fees granted to all appointed attorneys must not exceed those allowable if but one attorney represented or defended the defendant at all stages of the criminal proceeding. So we're just asking for clarification of that for these fees to be approved through the model plan or through the designee or our department.
Okay.
And this is similar 7.135. We are proposing that right now what happens is attorneys have to file ex parte motions for funds to be able to employ investigative experts or other individuals necessary to give an adequate defense. And what we're proposing at this point is that instead of that application going towards the judge first, what happens instead is that if it's a county with a population less than 100,000, the department or their designee in the plan for the provision of indigent defense services, or in counties with a population of more than $100,000 pursuant to their plan, you would file the application with them for approval. If that application for funds is denied by the department or their designee or pursuant to the plan, then that's where they could go to the ex parte motion through the judge to request funds for those services. So that would be the backup. Is Jeff trying to talk?
If anybody has any questions or just wants to discuss it, just jump in. Okay, go.
Nope, sorry.
You got it? Is there a comment or a question?
No.
No, okay, go.
The next request is 7.145. This again is similar to the prior, that these claims for compensation for representation, they would be submitted to, if there's a population of less than 100,000, it'd be to the department or their designee in the plan for provision of indigent defense services, or in counties with a population of more than 100,000 pursuant to that county's plan, that's who would be submitted to for payment. And each claim has to be sworn to, that's currently in the statute, but would be asking to cross out the portion that talks about payments in excess of the statutory limit, since we're no longer going to be having the statutory limit if our proposal is accepted. But we would add that we would request that the claim shall be reviewed and modified if necessary and paid pursuant to the county's plan for the provision of indigent defense services, and any dispute of the approval, denial, or modification may be reviewed by the trial court based upon reasonable and necessary standards. And we should probably put in there that it be paid pursuant to the department or their designee in the county's plan would probably be more appropriate in subsection 3.
And I just want to throw in here, Bob, if I may, that
Sure.
I took Marcy and Jared's original draft and sent them 10 pages worth of notes, and they made a bunch of changes, and this is one of the ones that I think they sort of followed my suggestion, and I just wanted to publicly thank them both for all of the amendments that they accepted of mine. I have a couple comments later, but I wanted to thank them for all the stuff that they did accept along the way.
Okay,
Okay.
thanks. Get that one more time. You take it. You got that.
Okay. The next one is 7.155. This is kind of a housekeeping matter where currently the state public defender handles the post-conviction claims, the bills for those. And we would like to move that process into our Department of Indigent Defense Services. And, you know, truly the meaning behind this is the state public defender should be able to be out and doing public defender work rather than processing payments. We have management analysts in our department, and these can be things that would be handled within our department more easily. So we are requesting that compensation be done through our department rather than the state public defender. So that would just move it from their budget into ours. I am adding one thing, however, and that is proceedings related to representation of a prisoner under NRS 212.070. Currently, what happens for payments, if you're appointed to represent a prisoner, is you have to submit your billing to the AG, and then the AG submits it to the governor's finance office for payment. If you're a defense attorney, you don't necessarily want to release who your experts are or request for payments or let them know what you're doing when you directly have to provide that to the Attorney General's office. So I think that if we could put that within our department as well to process the payment for the attorneys, possibly they would get their payments more quickly, and they also wouldn't have to release any information as to who their experts were before they were required to release that information.
Marcy, real quick, this is Drew.
Marcy, this is
Marcy, this is Drew. Can you hear me?
Yes, I can.
Do you envision by your changes to 7115 and in combination with 7125 that your department will now collect vouchers statewide on post-conviction cases that won't require a court order?
No, I think that I'm not intending to change the voucher system because we would still need a court order for payment. At this point in time, my understanding is it's basically processing the payment through that post-conviction fund. So it would still be the same process. It would just be done through our department where we have management analysts rather than through the Office of the State Public Defender.
But as I'm thinking, your changes to 7125 kind of takes the court out of the payment process, doesn't it?
That wouldn't necessarily be for post-conviction. I don't think that applies for the payment of post-conviction. I think post-conviction is in NRS 34.
Okay, I'll make comment then when we get there.
Okay. Are there any other comments, Julie?
Yeah, I just wanted to make sure. So the way I'm reading this, it's kind of like the same way that the selection or appointment process went in that counties with a population of less than 100,000, they could basically opt in to continue the way they're doing it now, where the attorneys send in their request to be paid, and then the district court reviews that and either approves it or denies it for all pre-conviction cases or all non-post-conviction proceedings.
The plan that we would be proposing would be to have someone other than the judge reviewing that payment. So that could be the department, or it could be some sort of administrator.
But those monies would still be paid from the county fund. So how does the county know that some outside entity is not just reviewing these and just signing off on them. I think, at least I know out here, I think the counties feel pretty comfortable because they know that district court judge is going to watch their budget pretty tightly
Well,
when
I
they're
think that,
reviewing these.
I think possibly Drew could weigh in on this, because I know that that's what's done in Clark County is a separate person does that. But we are also proposing a maximum contribution that the counties have to make. So there will also be state money, which we are attempting to get for the counties to help support them in these areas.
Yeah, Julie, that's why this is Drew. I asked the question on the post-conviction because for a decade now here in Clark County, we don't have any court oversight of pretrial expenses. It's always been our position that under ADKT 411, the independence from the court on any kind of request, whether it be the attorney's work itself and their fees or any request for investigators and experts and the cost should be out of the executive branch and not out of the judicial branch because it takes away it gives independence to the or takes the dependence away from the court. So that's why I was asking the question as it referred to post-conviction. I don't like the way it is now for post-conviction, and quite frankly, our judges here in Clark County don't like it either. But that's a discussion we can have down the road. But you're telling me in your department, if a private attorney asks for an investigator or expert, those bills are run through the district court for signage?
You're asking me that? This is Julie.
Yeah, I was asking,
Yeah, that's how it works out here. We file a motion with the district court. We can file it ex parte, so the other side, the defense obviously doesn't see what we're asking for, but then that's up to the district court judge to approve or deny. And for the most part, I mean, they pretty much always approve them. There might be questions about the amount. But Judge Shirley raised this issue with me specifically. He said, if those requests are going to the state and the state's approving them, and I think you guys just answered this question, but he said that should be paid through the state then. The county shouldn't be responsible if they're the ones making those decisions. And another comment, he says, what if, yeah.
I'm sorry, Julie, go on. Well, to me, there's a couple. Julie?
Yeah, sorry, I just put it on mute so you can talk.
Okay. The county is capped, right? Going forward under AB 81, whatever that number is for indigent defense. So for speaking to Judge Shirley's concern, they know that if it was $100,000, that's what they're going to be paying. So the idea of the judge watching the county's funding is not as crucial as it's been in the past to them. So really, anything over what the cap is will be paid by the state. And as a practitioner, albeit a while ago, it is, I think, probably one of the worst things to have to go to a judge and say, I need a fingerprint expert because X, Y, and Z, and then the judge approves it, and then guess what? You don't call the expert. The judge is no fool. He knows why. Anything about strategy, if it's the judge, and I think that's what Marcy's talking to, like in Drew's case, it can be an administrator. But if it's somebody without like a real strict wall between the judge, the finder, the judge who's going to be ruling on the motions and maybe making findings of fact and sentencing, learning what the defense strategy is in terms of attorney billing and expert requests is nothing, there's nothing fair about that. So I know Judge Shirley thinks, well, the state's just going to spend all this money. It's going to be the state's money over what these counties already have budgeted. And this goes to the heart of indigent defense because the DAs don't have to look for this. They just hire whoever they want as experts. And wealthy people who can afford their own lawyers, they don't have to disclose to the court their strategy or what experts they're conferring with. So I hope that Judge Shirley understanding that really, the Department of Indigent Defense Services is going to be spending primarily state money on these things. It should alleviate those concerns.
Okay, thanks, Laura. I'll let him know that.
So going on to our request, I don't know if there's any other questions, but 7.165 would be a similar housekeeping matter to if those post-conviction funds or anything comes out of the Office of the Public Defender, it would generally be coming out of the department's budget, so just for clarification of that. $34.750, we did originally make some recommendations for some additional changes. And, one thing that we're going to bring up later on is the definition of indigent defense. And we could possibly have skipped to that, but the definition currently of indigent defense is an indigent person who is charged with a public offense or an indigent child who is alleged to be delinquent or in need of supervision. So I don't know if this board has authority under NRS 34.750 cases because that person is not charged with a public offense at the time. They have been convicted and they're challenging it. So with that recommendation, we are just requesting that the money that was appropriated to the Public Defender's Office be appropriated to the Department of Indigent Defense Services for that reserve statutory contingency account. But I don't think that this board has authority to make any other recommendations. But that's something that we are wanting to discuss more at length later on, unless there's comment now.
Mr. Christensen, this is Jared Hickman. Is this the area in which you had a question regarding the payment of post-conviction?
Yeah, that's always, and thanks, Jared, for reaching out. All fees for services in Clark County are just now run through the executive branch and under the same kind of thought process that Laura had just mentioned. And our post-conviction work still requires court orders. And many of our judges down here in Clark County don't like still being part of the process because of the independence suggested or ordered by ADKT 411. And so I didn't know if there would ever be an appetite. I remember talking to Diane Crow about this years ago, and then Karen more recently, if there would ever be a feeling by your office to just review the indigency bills for habeas that come through and kind of make some own declarations of reasonableness about the case without having court intervention, because we've had numerous cases where the court refused to sign the voucher. Now appreciate when this happens is all the work's already completed. The court will reach out for an appointment in a particular case, the work will be done, the hearing will be had, and potentially even the appeal to the Supreme Court, and then the district court won't sign the payment. And so we've had, it hasn't happened a lot, but we've had a couple of attorneys who've had to appeal the decision of the court not to sign the fee order that the Supreme Court has remanded it back to pay it. And so I think if we ever just wanted to make the decision to take the courts out of any kind of intervention of investigative requests, expert requests, legal fees, since your office is paying the bill in the first place, and that's where you asked in that previous statute to move the funds from the state public defender to indigent defense, I think you as an executive branch could make some determinations as the kind of case, the length of trial, and make some determinations as to the reasonableness of the fees in question. And so I know Clark County would appreciate not having to get court orders, and I know we are a bulk of the work that probably comes through your office, but just something to think about.
As Marcy had indicated in our original draft of this, and I'll try to be speedy, I know there's some desire to move forward in these, but in our original draft on this statute, that was, the same changes that we've made in other areas about the payments being reviewed by the Department of the Designee was But as we work through it, and you'll see it, we're definitely going to get to it here in just a short while with respect to some other statutes. The definition of indigent defense services, which kind of defines the scope of, well, not kind of, it does define the scope of the board and the department, is limited to only those instances where the Sixth Amendment right to counsel has been guaranteed under federal constitutional law. So, the felonies, misdemeanors, juvenile delinquency. And, in reviewing that and taking a look at that, the post-conviction work, given that definition, we didn't know if it was appropriate to include our department as a reviewer unless and until the definition in 180.004 was changed.
Well, it's a topic we can continue to discuss down the road, but it's just something that I think could be remedied, but I understand your point.
It's coming up soon, so that's definitely on the table today. That definition is coming up here pretty quick, so I think we'll have an opportunity to discuss that in some further detail.
Okay, and just in terms of timing, I have 3:30 now, and we've got a lot to go through. I don't know what the chair is thinking, how long we'll be going, but I'm going to have to make a phone call if we're going.
Step out if you have to. I'd like to get as much done as we can today.
Okay.
I know this is long, but if you got to step out, if we're blowing a quorum, we'll call you back in.
Good.
So that we are withdrawing our request for 34.980. Any changes to that, and we'll explain that further when we get into NRS 180. NRS 171.188, this is similar to the appointment and selection that we pointed out previously in Chapter 7. It just puts in there that although it's the judge that appoints, it will be referred for selection. Again, the population breakdown less than 100 by the department or their designee pursuant to the county and or municipality's plan for the provision of indigent defense services, and then the same for over 100. NRS 170. I did also want to point out, thank you, Jared. NRS 171.188, subsection 4 does have a cap in municipal cases for $75 per case. We are proposing removing that cap, which is also consistent with the Davis case recommendation. NRS 171.196, just again clarifying the difference between appointment and selected. So if the application is...
I apologize. Back on 188, did you still leave in where you split the municipal and the county? Is that still in there?
It is.
All right, thank you. Keep going.
That was Jeff Wells' recommendation. Thank you, Jeff. 171.196, like we said, just clarifies selected pursuant to NRS 7.115. NRS 180.010, this is just something thrown out there that the department or the Board of Indigent Defense Services shall select the Nevada State Public Defender for that term. Currently, the public defender is appointed by the governor, so I didn't know if we wanted to change it to the board or the department selecting that public defender. And that would remove the concerns over, political interference if the governor is the one appointing them. NRS 180, this is the grants or that gift account. We've already talked about this and accepted this gift account so we can get grants or things in the future. NRS 212.070, this brings us back to defending a prisoner. These are state expenses specifically, so we'd like to say that the compensation and expenses of that attorney are a charge against the state, which they are currently, and must be paid from that money appropriated to the Department of Indigent Defense Services pursuant to NRS 7.155, and that after those funds are exhausted, we must be allocated additional funds. NRS 260.040, compensation of a public defender must be fixed by the Board of County Commissioners. We'd like to add and in compliance with the regulations of the Department of Indigent Defense Service. We do have a proposed regulation that there should be parity between the Attorney General's office, the DA's office, and what providers of indigent defense services shall be paid. Jeff Wells also made the recommendation to delete subsection 6 regarding the merit system. NRS 260.060, this again just kind of clarifies the appointment process, and then it should be referred for selection pursuant to NRS 7.115. So it just breaks out that definition. This was a request of Kate Thomas, which is also a request of the Washoe County Public Defender's Office and alternate Public Defender's Office. Under NRS 179A.030, it defines an agency of criminal justice, and the purpose of this is to be able to get criminal history checks. Right now, public defender's offices are not allowed to go through the Nevada system for checks. In reaching out to Darren Imlay in Las Vegas, they do have the local checks, but they don't necessarily have the statewide. And we believe that if we add public defender office, they'd be able to have access to this for investigation purposes and wouldn't have to go through the district attorney to try and obtain this information, which is obviously necessary for impeachment purposes. So going back to our conversation of NRS 180, the board is limited by indigent defense services. So under subsection A, you have to provide direction to ensure that indigent defense services are provided in an effective manner through the state. The board has to review caseloads of attorneys who provide indigent defense services. We have to direct audits or investigation to determine that the standards of indigent defense services are being followed. We have to develop procedures for data collection for indigent defense services, and we have to review and recommend legislation for indigent defense services. So again, what's the definition of indigent defense services? Right now, the definition are these two things. An indigent person who is charged with a public offense. So this is where the concern about NRS 34 comes in, because they're no longer charged with a public offense. They've already been convicted. And then under subsection 2, an indigent child who is alleged to be delinquent or in need of supervision pursuant to NRS Title 5. But when we look at the statute specifically for NRS 180.060, those are the duties of what the public defender can be appointed to. They can be appointed in cases of NRS 62D.030, that's juvenile delinquency cases. That's in Title 5. 62D.100, that's Title 5. NRS 171.188, that's a person charged with a public offense. And then we have 432B.420. And we also have this discussion of NRS 34. When you look at the county public defender, they can be appointed in NRS 62D.030, NRS 171, and then also 432B. So 432B.420, those are abuse and neglect cases that generally happen in juvenile court. That doesn't appear to be within the definition of indigent defense services. So can we recommend legislation or even monitor those 432B cases that the state public defender and the county public defenders are at this point required to take under the law? And it goes further to our original request was to change the definition of indigent defense services. We were proposing certain things like including 432B cases, which are abuse and neglect, 433A cases, which are involuntary commitment, or these NRS 34 cases, which are the post-conviction. But those at this point are outside the definition of indigent defense services. So we don't know if the board believes that they should walk within the realm of the definition of indigent defense services as it currently is, which are these things, or whether we should increase the authority of the board by increasing what's in the indigent defense services definition. And I know that when we set forth this definition, we pulled this out of the model contract. Is that correct?
It was the model plan from the Supreme Court. That definition was used in both the Washoe County model plan
So, are you ready for comments, Marcy?
Yes,
Fire.
let's do it.
All right, so I think I was one of the ones who pointed out the 432B problem. And at a minimum, I think we need to strike out 432B. And as you pointed out, Marcy, there's a couple other statutes that make cross-reference to it that we probably should clean up well, because as you pointed out about 2 slides before this, one of our duties is to establish, caseload standards for anything that's an indigent defense service. Now, 432B have nothing to do with criminal. They are not delinquency cases. They are civil dependency and neglect cases. And if we include them under the definition of indigent defense services, we're going to be tasked with creating caseload standards for family law practitioners who never step foot in a criminal courtroom in their entire career. And it just seems like that's not an expansion that we want. We should not only not put it in our definition of indigent defense services, we should clean up the one little reference out there where it looks like they were trying to appoint a public defender in those cases. And I can go through lots of detail about how we do provide attorneys. Under 432B, we are required to provide an attorney for the child. We are required to provide an attorney for the parent. But in those cases, when you get to the actual specific statute, it does not say public defender. It says an attorney. We have a full system for how we do all those appointments.
Chairman Kroll, this is Franny. I completely agree with Jeff Wells.
Okay.
And that,
wow.
Yep. Yeah.
Well, we got.
So the oversight that this board and the executive director, I think that the mental health appointments and the 432B appointments are just so outside of the realm of a criminal practice that it just doesn't fit here.
Okay.
So I guess what we are proposing in our bill draft request, I have NRS 180.060, subsection 2, we're asking to cross some of these designated duties out. We're asking to cross out, it's in red at this point, because I'd like your authority to cross it out, but 62D100, now Jeff Wells did bring this up, 62D030 is where an attorney is appointed to represent a child in a juvenile delinquency case. 62D.100 is if the court feels that it's necessary to appoint counsel to the parent, then they first go to the public defender, but how can you have the public defender take them if they already represent the child? So I think that might have been some sort of mistake previously. So I would request that we cross out 62D.100 out of the public defender duties, as well as 432B.420.
And I agree with both of those. Thank you.
Mr. Chair, Dave Mendiola, Humboldt County. Mr. Chair, Dave Mendiola, Humboldt County. We also have looked at this and have the same concern, and we agree. These need to be stricken from the record.
And Mr. Chair, this is Julie Kavanaugh Bill.
Yep. Hi, Julie.
Hi. I just want to disclose to the board that I do get appointed on a lot of the 432Bs, so I'll just stay silent on the issue.
All right.
In addition, we would like to add that language, and I would like the board's input on this, that the Office of the Public Defender, I don't know if the board would like to say may handle all death penalty and or direct appeals if it's less than 100,000, or if it's a shall. If the court would like to choose the language of may, then we propose the language that the county must notify the Office of the State Public Defender in writing before March 1st of an odd numbered year if they desire to transfer responsibility. And the responsibilities will be transferred at a time specified or after July 1st of the same year in which the notice was given, as determined by the executive director of the department. But once a county whose population is less than 100,000 has opted in for these services, they will not be allowed to opt out. So I don't know if the board would like to discuss the may versus the shall.
And the reason that we provided the distinction between the may versus shall and subjected that to discussion, originally, well, not originally, in one of the 80 KT 411 orders, the court recommended that the Nevada State Public Defender take the death penalty cases and appeals. As we were, going through our initial conversations with counties, some counties felt that, something to that effect would be appropriate. Other counties felt that something to this effect may not be appropriate. So to the extent that, we could balance that, that's why we provided or provided the discretionary language, but, ultimately it is the board's decision.
If I could speak to that, my personal preference would be very strongly that it be shall. Having done post-conviction work on death cases out of rural counties, I really feel generally that trial, although we want consistency of representation, by the time somebody is, the death penalty, if we look at these, I mean, like right now, I don't know how you guys are feeling, but whoever's handling that case in Winnemucca, it's just very, and it's the Wybara case, Mayor, that your firm handled. If you have a death case in a small county, financially it's devastating. And the one thing that would weigh against the filing of the death notice is but now we're paying for excess anyhow. Sorry, I'm just talking as I'm thinking. I really feel very strongly that in the few death cases that are going to come out of the counties of population less than $100,000, it should be the state public defender because of the resources, because of the community stigma that can, I've seen it. I mean, there are people on death row that, they're lawyers that got death threats or threw in the towel and whatever. So anyhow, I feel very strongly personally, based on history in rural Nevada, that the state public defender should take these cases.
Well, it relieves the.
Excuse me,
Oh,
this
sorry.
is the state public defender. I certainly would welcome the case work, but again, my concern is we're not budgeted or staffed to take on that responsibility. So my only concern would be if we were to have to travel the rurals and provide a death penalty qualified attorney, we'd need substantial funding to hire investigation and hire death penalty qualified attorneys who are willing to travel the rurals for extended periods of time.
And this is Julie Kavanaugh, Bill.
Go, Julie. We'll get back to you.
I know.
Go ahead, Julie.
So we actually have a new death penalty case here in Alco. It was handled very quickly by the courts, and it's a local attorney. He's actually a former district attorney who's state death penalty certified, and co-counsel will be one of the attorneys from the public defender's office. But I think because it's moved quickly, both for the family of the alleged perpetrator and also though for the victim's family. And I think the community has really appreciated the courts handling it so efficiently. I don't think that would have happened if we couldn't use one of our local attorneys who is death penalty certified. So I think it should be May. I think it comes across somewhat paternalistic if we say, the rurals can't handle these cases. I think if they've got death penalty certified attorneys that they can access, they shouldn't be required to impose that burden on the state public defender.
Well, Julie, I'm sorry to bring this up, but was this the case that you were posting about on Facebook, that horrible recent case?
Yeah, the little girl that was murdered is a close family friend.
I know, it was horrific. I'm so sorry. And that was resolved by a guilty, was that resolved by a guilty plea?
He hasn't pled yet. His arraignment is next week. But I'm assuming he'll plead not guilty. He's got the death penalty on the table.
Right. Okay. All right. Well, I certainly understand that. It's a good point you make.
Yeah, and both the families are local, and they've had ready access, and then having his attorney right here locally. I know that attorney is able to go over to the jail, meet with him, meet with his family, and provide that instant in-person service.
And I think that what we are proposing here is to build this into the budget in the future. So like we said earlier on in the meeting, that we would do a fiscal note analysis to try to determine how much the cost of this would be, and we would propose building our budget so that we would have sufficient personnel to handle the appeals as well as the death penalty cases. I think these death penalty cases could be something that could be addressed in the model plan. If they would like to work with the state public defender to have the lead counsel be from the state public defender's office and possibly the second chair be local attorneys so that they could get experience as well, that's something that we could work out in the model plan.
Mr. Chair.
Yeah,
Dave
go.
Minnie, Humboldt County. I would agree with May. We recently had one that ended up being pled out, but it would have been devastating to us. I think the idea that was just mentioned about having a state council run lead and the second chair be one of our local people, that's one great possibility, and there might be times when we can handle it, like Julie says. So, but, I think shall is a strong statement. Let's just go, I would say may is fine with us.
It's fine with me too. I'm persuaded. Laura Fitzsimmons.
So would you like the language? This was also proposed in our discussions that once they opt in, they cannot opt out, and this is for the purpose of building budgets. Because if they're jumping in and out, obviously handling the appeals and the death penalty will be expensive for the state. To build that into the state public defender's budget, would cause significant changes if they're able to leave, depending on the year.
Marcy, this is Jeff. So can't you just amend that they can't opt out without permission of the board? And that way, if a county decides they have enough extra money in the future, they could ask the board to be able to opt out.
We can change that if that's what the board would like.
It's not a bad way of doing it.
This is Julie. I would agree with that language as well, because then as a board, we can look at the budget, we can look at those items and see if the opt-out is going to cause, harm to the department or not, or if it's okay.
What would happen if you said the Office of the State Public Defender, in consultation with the Board of Indigent Defense, may handle all death penalty cases?
Well, I think we would need to think about our budget build, right? So how would we know what we have?
Because you're not going to be able to budget it? I'm okay with May.
Okay, so then I will make the changes of that they may handle it, and instead of not be able to opt out, it'll say that they cannot opt out unless they receive permission of the board.
Okay.
And the notice provision remains, that they have to do it by a certain time.
Yeah.
NRS 260.050, we would request permission, like we crossed it out in the NRS 180, to cross out 432B.420. And going to 62D.030, we have made changes from the PowerPoint. After further discussion, we think that it would be appropriate. This again breaks out the selection and the appointment, just that the selection be referred to NRS 7.115, which again breaks it down to the department or their designee through that county and or municipality's plan for the provision of indigent defense services. And if it's over 100,000, that consistent language. $62D.100, we would withdraw this request unless, this is still, excuse me, I'm going to rephrase that. So 62D.100, this is for the appointment of counsel for the parents. So we would ask that we handle this through the model plan, because it wouldn't necessarily be going through the public defender. It would have to be alternate counsel, right?
Conflict.
Yeah, so it'd be a conflict counsel. And then in subsection 2, it says each attorney other than a public defender who is appointed. Since the public defender in our purposes would not be appointed anymore, I believe that we would request permission to cross out other than a public defender.
Marcy, this is Lorinda. Could you tell me what page of the slide you're on out of the ones that you emailed? I got lost.
32.
Page 32.
Thank you.
62D.100.
Marcy, this is Julie.
Yes.
I'm a little confused by the language, that second sentence in subsection 1. It says the juvenile court may not order the appointment and refer the selection of an attorney pursuant to, and then A, in county population than 100,000 by the department pursuant to the county's or municipality's plan. So is that saying the court may not order it, or that the court must order it pursuant to the department or the plan?
They may not order the selection and appointment unless they find out that it's in the interest, required in the interest of justice. So I guess we could fix the wording of this entire sentence, but we didn't necessarily except adding selection. We're getting feedback from someone's phone or microphone. I don't know if we're on mute. If we could do that if you're not talking.
It sounds like wind.
Yes. Okay. Moving on, because of our discussion, we would withdraw. We were originally requesting that the termination of parental rights be included because it was in that definition of those plans that we were looking at from the Supreme Court, but it doesn't appear to be within the definition of indigent defense services. We also are withdrawing anything regarding 432B, 420. But we are requesting to cross out some language in NRS 433A.270. This is an involuntary commitment. If a person is in a mental health crisis, an attorney can be appointed, and it says that it may be the public defender or his deputy. And again, this is outside the indigent defense services. We'd ask that we can cross that out.
I agree.
And then finally, and it's not in this PowerPoint, but I've noted the change of NRS 260.070 subsection 2 annual reporting, that we would propose that the date be changed from May 1st to June 15th.
Right.
Agreed.
Marcy, can you go back to your slide of 180.004 and tell me what we're doing with that? I lost track in there. Are we keeping that in? Are we taking that out and just sticking with the current definition? What was the decision on that?
We would propose sticking with the current definition, and we would withdraw our modified definition.
Well, I love that idea, so I'll just stop.
Don't sell past the sale, right, Jeff?
Exactly.
And I still agree with Jeff.
Good. Anybody have any heartburn on it? This is a lot of bills that we got, a lot of legislation that we're looking at here. Let me see if this works. Has anybody got any question that we should debate one of these requests individually? Is there questions on it, or are we ready? Can we vote on the package as a whole now?
Well,
what's your pleasure? I mean, if we want to
Mr.
hold
Chairman,
one,
this is Julie.
Hi, Julie. Yeah.
Hi.
So,
I hope she doesn't mind, but we have the Chief Public Defender here from Elko County listening in, Miss Kristen Hill. And she had a question on the whole removal of the 432B. Would it be appropriate at this point to have her make a comment?
I think so.
Okay. Thank you. Sorry,
Miss
Hill.
Sorry, guys. I was trying to get this unmuted. This is Kristen Hill, as Julie said, Elko County Public Defender. So since the 432B cases won't be under the purview of the Indigent Defense Board, would our office be required to handle those cases anymore?
And
I
if
believe
we
that we are
are,
submitting a bill draft request to take that out of the statute of NRS 260. Currently, the law is that it appears that that is a duty of the public defender's offices, but we are attempting to clarify that.
But a literal.
Wouldn't that be a matter of the contract between your public defender's office and your county?
we don't have a contract. We're created by ordinance.
Well, whatever. Yeah, I mean, I think if your county ordinance requires that you do it, you'd still have to do it, but it wouldn't be supervised by this office.
And mandated by.
It wouldn't be mandated by statute if our bill draft request passed.
And Chestnut.
Well, and one of the other things with that then is obviously we spend a lot of time working on those cases, and having those cases impact our caseloads, which are monitored by your board.
But that's going to be true for every attorney that's out there, whether they be a contract attorney who also does traffic negligent cases and anything else. We're going to have to monitor their entire caseload to make sure that they still have time to do all of their indigent defense cases.
Okay, that makes sense.
And whenever you're ready, Bob, I would move this amended version of the BDR.
Second, Laura
Okay.
Fitzsimmons.
That's all of them, so.
All of
this is a
them
big
or
move.
just that one?
No, I'm doing the entire package that
Okay.
Marcy went through with all the changes
Got
we've
it.
made.
Okay,
Right.
thank you.
Okay, if this disturbs anybody by not going bill by bill, let me know. Otherwise, we'll entertain the motion. Speak now or forever hold your, what do they say there? Forever hold your peace?
Yep.
All right, on the motion, is there a second to the motion, to Jeff's motion?
Hi, Laura Fitzsimmons.
Oh, Laura
second.
did it. She sat right next to me. I didn't hear her. I'm sorry. Okay, on the motion, discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, nay? Opposed, nay? I didn't hear any, so that was done. Well done, board. Okay. Now where are we?
The next thing on the agenda, Chairman, is the model contracts and model plans. I know we're after 4 o'clock, so I'm going to be brief because they are only for discussion and not for any possible action at this point. The reason they're on here is essentially just to kind of provide a view as to the work product as it stands now. Obviously, the content of both documents is going to be, either is going to follow what happens with the proposed regulations. So this is kind of the initial draft following the NLADA model contract that is mentioned in the settlement agreement. The model plans, again, are just drafts at this point. We wanted to show kind of the direction we were going, subject to what happens with the proposed regulations. If there's any comment or questions about them, we're happy to take that now, or if the board just wants to wait till they're actually on the agenda for action, that would be appropriate as well.
Probably the best thing.
Submit our comments to you in writing.
I didn't hear that. I'm sorry. Who's that? Joni?
It's Joni Eastley. Can we submit our comments to you in writing?
Absolutely. If you'd like to email them to me directly, I would certainly appreciate that.
I will, because I do have some concerns about the model plan.
Okay.
Good.
And
All right.
this is Julie. Will these be sent out to all the folks doing these cases in the rurals and the district court judges?
We have provided them as an attachment, and it's listed that it was for discussion today, so we have complied with notice. We have talked to judges and indigent defense providers to let them know where we are going, so they have been made aware of it. We have not mailed them out to every single person, but we have made them available on our website.
We have the email list though, right? That Patrick was working on?
It's not, we have an email
All the attorneys.
list generally of all the attorneys, but this isn't a finalized version for vote yet.
Right. I was just thinking it'd be good to get good to get some comments, if there are comments out there at the beginning part of this, rather than waiting until we're almost ready to vote on it.
Yeah, we're not ready to vote on this one today, but I think, Joni, it's appropriate to take a look and send in your comments. And anybody else on the board, send in your comments, and we'll make sure that everybody's got plenty of time to look at these. So we're not time crunched. We're gonna have to take a look at our timing of these things because it just will. But,
and we'll also note that there
Okay.
is posted on our website as well under the materials for today's agenda.
Yeah.
So if you can just get the word out, hopefully anybody who's actively involved in these contracts in the rural counties is aware of the website and checking it. That would be interesting if they weren't, but just get the word out that this has been discussed, and any comments, if they can go to the website, look at this, and any comments they have, can be submitted by anyone in writing.
Right.
Okay, I'll do that from my end.
And we do have plans, Patrick and I are talking about going to each of the counties and meeting with the county managers and proposing, these things with them first and seeing where the county managers are and the Board of Commissioners, because they're ultimately the ones that will be entering it. So that's who we would like to reach out to next, once COVID-19 allows travel.
And the final comment I would make is, again, these were provided to the board to see kind of the direction we're headed in light of today's conversation regarding the scope of the department and the decisions that were made with the bill draft request. There is some additional editing that needs to go into them to remove some things. So that's kind of the status of where they are now. They're certainly a work in.
Okay. I think, Joni, does that help a little bit?
Yes.
There isn't going to be a motion on this stuff until we've heard from you.
Yeah, that's great. Thank you.
And I could say we've got your okay. How's that?
That's good.
Okay. Thanks, Joni. All right.
Thank you.
All right. Anything? Go. I'm sorry. Did I step on somebody's conversation? Didn't see it. Okay. All right. Are we ready to move to the next? Just an update on where we are with the
Update on the regulations. We've submitted the regulations to the Legislative Council Bureau on March 31st, and generally pursuant to the statute, they should have them back to us within 30 days, but there are delays due to COVID. So I have been reaching out to them asking when they will be back to us. I have not received any sort of response, but I have been told by our Attorney General that once we set them back or receive them back, then our department can set a workshop. We don't need any sort of board vote on setting a workshop, but we can get that set.
Okay. All right. Everybody understand that, where we are on the regs? In process.
In process.
In process. Yep. Okay. All right. Future meetings?
The next meeting we have scheduled is June 18th in Tonopah. We are requesting permission to cancel and reschedule the Tonopah meeting, considering the restrictions on travel, and would like input on when we should have the next meeting.
I'd like to go to Tonopah, to tell you the truth. Whether we do it on the 18th or we do it around that time. I think, how do you set these meetings anyway? I mean, you get a vote from us, or can you send out some dates when we should have them?
Well, part of the problem that we're having is we don't know if the virtual meetings will extend. It's extended now until the 15th. After that point, we need to contact the places where we could have the meeting to see the availability, but they are not opening up their calendars until we know if they'll be open. So we could set, a period of time where you think you'd like to have the meeting set. If you'd like to have it set, towards the beginning or end of June, we can start looking for dates.
I think maybe I'm just overstepping my bounds here, but I think it's good to go down to Tonopah for a day and we can all chat and get to know each other, and I think it's the right thing to do. So if you'll send out some dates towards the end of May, is that right?
Well, we currently have the Tonopah meeting scheduled for June 18th.
Is that going to come off? I mean, it's probably going to come off, but do we know that there will be no in-state travel restrictions? No.
We do not know.
That's why we're rescheduling.
Say that again?
That's why
Jody?
that's why she wants to reschedule, because we don't know.
Yeah, I don't know if the governor didn't open that up though, did he?
He did not. We are going to be going into phase 1, is my understanding, on Saturday, but state offices are still closed through phase 1. So
I don't know what they're doing. We're open. I mean, we get stuff done. Okay. All right. Set out an alternative. Let's set an alternative time to drive down to Tonopah.
okay, so are we having a meeting in June? Will
Yes.
it be in Tonopah
Let's
or
see,
not?
June meeting in Tonopah.
So would you like to keep it June 18th?
Well, let's keep it to June 18th until we see what's going on with the travel restrictions. I mean, what is that? That's 30 days from here? More than 30 days? We may just make that.
Okay.
Keep it to June 18th. Is that all right with everybody? If we'll just leave it on for June 18th right now, and if it looks like we're not going to be able to comply with the shelter in place orders of the governor, we'll move that meeting. But otherwise, we may well just, we're going to probably be able to make that meeting in person in Tonopah. It's my sense anyway. So we'll deal with that one internally here and let everybody know where we are on the future meeting. All right?
Okay.
That's
All right. Well, what else
Any
we
public
got?
comment?
Any concluding public comment? Anybody? Any public or
Mr.
board
Chairman,
members?
I just have one item. I was emailing back and forth with a member of the public who was trying to access the meeting at the State Supreme Court's website, and the video wasn't working. So I don't know if you're going to get any complaints about that, but the player wasn't working.
Really? What office was that in? At the Supreme Court?
It was on the agenda, Mr. Chairman, to use the live audio or the live feed on the State Supreme Court's website, and they attempted repeatedly, and I also attempted to see if it would work, and it did not.
Hi,
I don't know if that's going to be an OML problem or not.
Yeah, I've been talking with John over at the Supreme Court. This is Cindy speaking, and evidently.
Hi, sorry, this is Ashish from the AG's office, Deputy AG. I'm here as OML counsel, and I understand there is an issue, but it's not on the agenda and not something we should be discussing at this time. So we should just stick.
It is absolutely something we should be discussing at this time. It's an open meeting law problem. That the video was not working and the public was not able to view the meeting. It is absolutely appropriate that we should bring that up.
I do understand. Oh, my apologies. It's being brought up under public comment. That is okay, of course, but there cannot really be discussion amongst the board because public comment is not for discussion.
Well, I guess the question is, from the AG's perspective, the fact that the video feed didn't work at the Supreme Court, does that create an open meeting law violation?
There is potential, of course, for liability under the open meeting law, but the board is required to engage in reasonable efforts. And if there is some issue in the link or the telephonic access, then of course that is something that would be considered upon the submission of a complaint to the AG's office, but that's not, frankly, something to be discussed at public comment. But we do appreciate the public comment notifying us that there was an issue so that we may remedy that and ensure that the link is working moving forward.
All right. We may have some.
Well, we did release the link that everyone signed in on to interested parties. So all interested parties had the sign-in code and the phone number, and that's why there's additional individuals than the board members. And we did provide an ability for public comment via email.
Okay. Well, not certain we have enough. I know this is discussion under comment, but I don't know, let's see what goes down. I mean, one, I don't want to get hit with an open meeting law complaint. Two, I don't want to think that people are getting cut out of this stuff. Joni, I think we're just gonna have to let it play out like it is and see what happens on this.
That's fine. I just wanted to bring it to someone's attention, that's
word
all.
to the wise that, you know, maybe when we do these virtual ones, I don't know how much longer we're gonna be doing it, but maybe, you know, we ought to take a moment and not just see what board members are here, but see if all our other links are working, see if anybody's on them. It's hard to do that, but, all right, let it sit for right now. Any other public comment? Anybody? Everybody ready to go to the weekend? Everybody got your mask ready to go? Yeah.
This is
Wells,
Jeff.
go.
I just want to once again thank Marcy and Jared for all their work on the legislation. I know there was lots of variations of it, and I appreciate it. And I want to slightly apologize for taking up so much time on my earlier issue today.
It was important, Jeff.
Yeah, there's no, I think that was a great discussion. What it's all about, All right, do we need to do anything more before we quit? Is everybody done? Because I'm gonna say we're adjourned. All right, I'm gonna adjourn unless there's objections. Is there an objection to adjourning? Probably not. Okay, without objection, we are adjourned until the next meeting scheduled will be scheduled by Marcy. It's tentatively, but it's been taken off calendar for the 18th. We're gonna see where we can meet in Tonopah. Okay? All right.
Thanks, everyone.
Thanks, everyone.
Thank you.
And thanks to our students too. I'm gonna give these to Marcy. She's got all these, so she'll take them down there. Are they still on with us here? They left. That was very, very good. Thanks, Ann, for doing that. Not only is it the right thing to do under our, under our statutory authority, but it's the right thing to do for these students too. Good move. All right. Anything else? Thanks, everybody, for your participation. Thanks on behalf of the Indigent Defense community. We're ready to close the meeting. We're done. Okay. Thank you.
Thank you, Mr. Chairman.